The criminal petition stands dismissed.
Prayer for adjournment, if any.
Great, Your Lordship. My Lord, I am seeking Your Lordship's indulgence for posting of a urgent bail application filed on Saturday, that is, my Lord, a day before yesterday, pertaining to bail application, anticipatory bail, which was posted today. If Your Lordship remembers, we had moved this application AB, and the anticipatory bail is fixed as item number 46 today in this supplementary list pertaining to the accused, namely Ritam Singh, my Lord. So there, my Lord, we have come to learn that there was a
48.
46 of supplementary list. So the AB is already posted before, my Lords. So we have filed a BA, my Lord, before this Honorable Court on last Saturday. We are praying for posting the matter, if not inconvenient for my Lords, to my Lord, along with this matter, my Lord, whereby we will be withdrawing the AB as we have undertaken, and a submission was made last occasion by my senior that since he was arrested, so we need to file a regular bail application. So we have accordingly filed a regular bail application. We are just seeking Your Lordship indulgence in allowing us to basically hear the matter. As per Your
You
Lordship.
have already filed.
Yeah, the filing number has been given.
Here we have some issues. Yes.
Yes, madam. But
The BA will come for motion.
in the connected
there is some-
AB, but there is an order of this court where case diary has been called, my Lord. In the connected AB.
That's what I'm just going to say.
Yes, ma'am.
There's some technical issues. Most
Yeah.
probably that order was not uploaded.
Okay.
So CD, most probably you have not called for.
Never mind, my Lord. Then my Lord may post this matter and let them appropriately take time the moment the case is posted before your court.
But before you, we don't have any dates.
My Lord, I'm
Now
just
this
saying-
one I can fix it.
Add
This add to, okay.
to, madam.
Your
Only
BA,
we are-
BA,
only
is
we
it
are-
numbered?
Yes, my
Numbered?
Lord. But the filing number has been given, my Lord. So after the filing number, if Your Lordship allows for posting at 2 o'clock, then the main bail application number will come, my Lord.
Okay, that will be done.
So at
Add to.
2 o'clock, madam, I'm highly obliged.
That is a lot. Yeah. Actually, adjournment loss of item 13, 14, and 15, all are certificate for the commercial. Commercial and EBS commercial.
13, 14, 15.
Lot.
You paid for an adjournment here.
After vacation, what will be there?
Yes, 13, 14, 15.
13 losses will be the TRI losses that I have already informed.
Informed them.
And 14 and 15 are state. I will say so.
Yes, after Bihu will do,
Any dates, the convenience to cook.
date will definitely, it will,
Any lot, the first week of May also.
First week
do.
May.
So any lot, convenient to cook.
9/5.
Lots of them.
At the
Also-
request made by the learned counsel, Mr. S. Mohan. All matters are adjourned for 9/5. These are different,
All are different. matters.
different.
Much obliged, much obliged.
And connected phase, my lord, scan copy is available and matter is still before they are complete.
Maybe 3 now, 3 is not available. Who is another senior court? Manasri Madam, 18. Court number 18, make a mention before. Court number 18.
Lordship, I beg to mention item number 40 of today's list, Lordship.
40.
40. In the cost title, there are certain Lordship deficiency defects. So, Lordship, I may be allowed to withdraw this with liberty to file affairs. I will, so that I can make the deficiency.
Hard Mr. You are Mr. B. Datta. No?
You the
U Datta. Hard Mr. U Datta, learned counsel for the petition. It is submitted by Mr. Doctor that due to some technical irregularity, he wants to withdraw the same.
the
You
cost
are-
title.
Technical irregularity in the cost title of the petition, he wants to withdraw the same. Want any prayer? Prayer,
Maybe.
which a prayer for filing afresh. Prayer allowed. The present petition accordingly disposed of and withdrawn.
May I please, Your Lordship?
Yes, is what? tomorrow.
Which is a lordship. Lordship, I have filed a petition. And out of same FIR, one item is listed to the lordship. Item number 32. That item may be take lordship. That's two lordship.
Yeah, when you have five,
I have filed to the lordship.
today,
Lordship.
it will come on tomorrow only.
Lordship, Act two may be taken.
How many papers will fix at 2?
Yeah,
Some other works also.
out of same FIR, lordship.
Huh?
Out of same FIR, lordship.
And nowadays they are doing that tactics. So for the display this to the kind of they're doing that tactics. Sorry. At 2, I have a VC also. I don't know if it will reach or not.
That's
I
the
won't,
last item.
I won't give it at 2 or whatever. 32 will be called for. If your matters come, then we'll take together. If your matter reaches by
Lordship,
when we 32 is called for, then we'll take it.
lordship. Obviously.
Yes, your lordship. Lordship, I beg to mention a bail application for listing in motion members.
We pray before port number 18. Make a mention before port number 18.
My lord, NDPS Act.
1818.
Special.
Oh, sorry, special act.
Yes.
Then 24, how can we? We are the senior court. In that case. It make a mention before 18.
Please, Lordship. Lordship, I beg to mention on BA application 824/25 for withdrawal. Withdrawal of the petition.
Tomorrow.
May I please, your lordship? Lordship, I beg to mention item number 27 and 28 of today's list, lordship.
Hmm.
Lordship, in this case, whatever lordship city was called for, but as per my instruction, charge sheet has been filed, lordship. So objection may be given and I may be directed to appear, file the
27 and 28.
27.
Hey, maybe. Yes, we are received here.
We have not any instruction regarding filing of prosecution.
Do you have the numbers also, search it number?
I do not have the number, lordship. Lordship, if they can only over phone, they can collect the information, lordship.
Okay, there are 2. Not 2, you can collect the information. We'll try to. Both 26 and 27.
27 and 28.
Sorry.
This is POCSO matters, lordship. Plus
Okay.
61 is behind the word. But in the meantime, my instruction is that city has been, charge sheet has been filed.
Both the matters out of same FI?
Same file.
We'll try.
44 for withdrawal.
Please, your lordship. Petitioner does not want to press the matter anymore, lordship. So we want to withdraw.
Matter what have?
Petitioner does not want to press the matter.
Praise the matter. You are MS?
J. Ghosh.
J. Hard MS J. Still learned counsel for the petitioner. It is submitted that as per instructions of a client, she wants to withdraw the same. Prayer lot, the matter is disposed of according to withdrawal.
Oblige, lordship.
Item 2,
Wait, please, your lordship. Here, the accused is inside the custody since 324 days. Otherwise, the co-accused have already been enlarged on bail by this honorable court and Honorable Justice M.R. Pathak. Your lordship, these are the copies. On the ground that the grounds of arrest have not been informed, your lordship, I have also annexed the arrest memo along with this bail petition at page number 35. 35 is the type copy, 36 is the
35.
35. Not find the grounds of arrest for in this arrest memo size.
This is the arrest memo. Where is the 47? Any?
36 is the arrest bill.
No. 36 is also the arrest memo.
Yes, yes. There, your
The
lordship,
notice, I'm seeking notice. Notice 47, do you have annex? These are the arrest memo.
these are the arrest memo. Apart from this, nothing has been informed to me.
No, there will be a 47 notice also. That's what I'm asking, whether you have that one.
No, that I don't have.
Records may be called for. Scan copy of the.
Or if you can collect the certificate copy, we can place it as before us,
Then
if it is possible.
after some time, your lordship.
Okay, we're keeping it for time.
The next item also may be passed over for the.
Both the
I-
items are same.
Not same.
I mean,
The issue is
yeah, issue is same. If you can just place us before us this, the certificate copy, it will be good. Otherwise, we have to call for a question.
Item
দুইটা
4,
pending করে দেবো।
Please, your lordship.
Yes.
49 days behind the bar lordship, the FIR lordship will find on page. Page 9 lordship. Out of the arising same FIR lordship, the lordship have already granted bail lordship to one of the person lordship that which have annexed on page. Lordship will find lordship order on page 23 lordship. Same without considering the case there is lordship has granted bail. To length of detention lordship, this person was granted on 50 days. I am on 49 days. On the section lordship with the 60 days mandatory. Yeah. Bail, yeah. Agar district without CBDs. Page 25 lordship, we can see that para 3 of lordship order, the case there is not received as reported by the landed public prosecutor. In spite of that, considering the length of detention and the nature of allegation lordship, the bail was granted.
Your petitioner was on 18-2. Today is 49 days.
49 days and this was granted on 50 days. Only 1 day, I am sorry.
Yes, Gustami.
Lordship.
Otherwise, there's an allegation that from and go down, there was probably some cement bags were
Cement
stolen
bags.
and those were sold to someone.
No.
That is the case. Heard Mr. S. Muni, the learned counsel for the petition. And also heard Mr. D.P. Goswami, the learned additional PP appearing on behalf of said respondent. This is an application under section so and so in connection with so and so. It is submitted by Mr. Muni, the learned counsel for the petition that accused got arrested in connection with this case on 18-2-2025. And since last 49 days, he is in custody. Thus, the investigating officer got sufficient time to interrogate the present accused petitioner, keeping him in custody. But against him, what is the allegation? Your petitioner's name is?
I was the employee lordship. Some manipulation was found in my part also.
Pardon?
No, some manipulation lordship regarding theft of that lordship, the cement, some was suspected about me also lordship. I am the employee lordship, field employee of the informant.
Because petitioner was an employee in the state company and he is not at all involved in the alleged offense. However, he is still ready and willing to cooperate the IO in further investigation of this case if he is granted with the privilege of it. Next paper, Mr. Goswami, the learned additional PP submitted in this regard that there's the present from the statement of the FIR also, it seems that the present accused petitioners may be involved in the alleged offense and accordingly, he insisted to call for the case diary. Next para. Hearing the submission made by learned counsel for both sides and without going into the detail of the merit of the case, it is seen that every para 6 to my proper.
Earlier granted also employee of that. We are same footing lordship. They earlier granted and this present petition.
The para, PS number 24, para 6, 7, and 8, we can give sent. Eta submission aro agote dio heji. Mr. Munir's submission of dio. Mr. Munir further submitted that one of the co-accused of the present case was earlier granted bail by this court in BA number 750 of 2025, dated 27/3/2025, and considering the case of the present petitioner under the same footing, he may be released on bail on the ground of parity. Also on the ground of parity. It will milai diba, also on the ground of parity. It will milai baki 6, 7 in the submission. Okay.
Much obliged, Your Lord. Much.
Item 5,
Regular bail application.
Yes.
POCSO is there.
POCSO is there, I think.
More than 300 days.
Pardon?
Subset case more than 300 days here. But POCSO 6 is there.
So we have to issue notice.
Notice
POCSO
to
6 is there. Issue 6 or koribo, issue notice to the respondent number 2. So jurisdictional police station, noted to the officer of the registry, the public prosecutor, so and so. When it can be listed? CD scan copy of the case record along with the case diary be called for. List accordingly after due vacation. And what is the stage of the case as per you? Stage of the case, what is the stage?
Probably, I don't know.
Evidence.
Charge sheet no evidence, Your Lordship.
After due. Okay, well.
Obliged.
item 6,
May I please, Your Lordship.
Please.
That's a 480 application, Lordship. Petitioner was arrested on 29/8/2021.
20?
29/8/2021. Today is about 3 years, 7 months, 9 days. 1,317 days, Lordship. In this case, charge sheet submitted on 29/10/2021, Lordship. Then charge frame on 9/3/2022.
29/10/2021.
Yes.
CS submitted.
Yes.
Hmm.
29/10/2022.
Charge
Then
frame.
charge frame on Lordship 9/3/2022. We have annexed that document also, that page 31. Then 9 numbers of witnesses cited in the charge sheet. Out of 9, only 3 witnesses are examining, Lordship. And in this case, Lordship, 6 person name in the FIR. Among them, Lordship, already 3 got bail from this honorable court. I have annexed because of the non-examination of the witnesses. Time and again, those summon issued, but they could not produce the witnesses. So we have annexed the document, bail order of this honorable court, Lordship. It starts from page number 32. Order outside. This honorable court on. P12/2024, that is at page number 43, Lordship. And now also no witness examined.
Only modification of
And my
So
lord,
do you have annexed the latest, the order sheet, the last order, any order?
last order I have not annexed, but Lordship, this order, 3/12, I'm conducting the trial before the trial court, Lordship. 3/12/2024, 1 person got bail from this honorable court. Now, because
No,
of.
no, bail, I'm not on bail. Bail is there. You have already annexed.
Yes.
Now, my question is, what is the stage of the case? We don't have any. That's what I'm saying. Do you have any order sheet? Copy of order sheet or certificate copy of any order sheet?
If Lordship wants, then I can produce on day after tomorrow, Lordship.
Enable also maybe consider record picture.
Otherwise, if you call for the record, it will take time. That's why I just ask you, Ajay, if you can produce.
Can be on Thursday or Wednesday like that. Lordship. And this Bihan Kumar also not followed in this case. Lordship.
Have you annexed the notices here?
Notice, I have checked all the documents, Lordship. There was no notice, Lordship.
Notice
So,
wasn't
Lordship,
served.
kindly give me some time, Lordship.
Okay, if there is anything if you have taken the plea of the Bihan Kumar and
Yes,
all.
I've taken
So
my
we-
petition. I'll
No,
pay.
no, that's why I'm asking, you have to annex at least 1-2 documents.
Lordship. Or
47
can it
of-
be on Thursday, Lordship? Other motion item, Lordship.
Thursday to.
Or on Friday, Lordship.
No, Friday we are not keeping. I will
Thursday,
not be
Lord.
available.
Thursday.
By at 2 you can, otherwise today only.
All the record. I want to.
No, record to, they will call for, it will take some time. If you want to,
Regarding notice, Lordship.
regarding notice, and if any order sheets can be placed by today itself, can be.
বাকি মোৰ record আছে, তাতে নাই খালি।
Because you are verbally submitting that. No, that's what I'm saying, that you have verbally submitted that 4740 was not complied
Yes.
with, but whatever.
I'll place the with along with the additional affidavit. That is why my humble prayer before this honorable court to take up.
We don't have one, I mean, it's very problematic for us. When is the Parity? Or Thursday? Wednesday,
Wait,
9, this on 9.
on motion columns. How let's move.
Just on 9 in the motion for you. Oh.
7.
Page 9, my lord. In short, my lord, this is a long affair, my lord. What happened, my lord? The police lost the affair, my lord. He is alleging they received some secret information, my lord, and they apprehend the petitioner from Jurat nearly Guwahati, my lord. Nothing recovered from his possession, my lord. He was taken to his house, my lord. As per their allegation, 13 for 135.86 gram of heroin recovered from his room, my lord. That is the allegation, my lord. And he's in custody near about, my lord, 52 days as on today, my lord. 15/2 is the date of arrest, my lord. 15/2/2025, my lord. And my lord, we have approached the learned session court also, my lord. And we have a look the reject order of the learned court below, my lord. It is stated and narrated the story, my lord. The main part is page 27, my lord. Para 7, my lord. Married, my lord. Page 27, my lord. Upon perusal of the case diary, it appears that the accused Saddam Hussein alias Kasa was arrested on 15/2/2025, and since then he is in judicial custody. It further appears that the contraband involved in this case is 135.86 grams of suspected heroin. The investigation is still going on in this case. My lord, considering that the investigation is going on, it was rejected, my lord. Now, my lord, there are 52 days today, my lord. And my lord, his wife, my lord, the petitioner's wife, my lord, I have annexed the medical documents also, page 17, my lord. She is now, my lord, near about, my lord, 8 months conceived, my lord, pregnancy, carrying, my lord, pregnancy, my lord. So, my lord, detention period, my lord, kindly some mercy, my lord. Only 8 days left, my lord. And his wife is, my lord, carrying 7-8 months pregnancy, my lord. I have annexed the medical documents also. Yes, it starts from page 17, my lord.
Yes, Gusam.
Case only, lord. It's NDPS case B, my lord, amount, maybe B, lordship. We don't go to the case diary, lordship. Earlier, it was perused the case diary by the learned court below, my lord. Only considering the stage of investigation, it was rejected, my lord. Now, my lord, 52 days, my lord, and vacation then. Otherwise, my lord, the lordship may call for the case diary also, my lord. I have no objection. But as today, 52 days, my lord. If it goes after vacation, mandatory period will be over, my lord. That's the, my lord. That's why I'm praying, my lord. And his wife is, my lord. That's the problem, my lord. His wife is, my lord, 8 months pregnancy, my lord. And he's the only person to look after her, my lord. Finally, on medical ground, my lord. Considering length of detention, then my objection may be recorded in this regard.
Heard Mr. S.M. Mullah, the learned counsel for the petition. Also heard Mr. D.P. Goswami, the learned additional PP, appearing on behalf of state respondent. It is an application under section so and so in connection with so and so. It is full next for it. It is submitted by Mr. Mullah, the learned counsel for the petitioner. That present petitioner is in custody since last 52 days. And hence the IO was sufficient time for his custody interrogation. So nothing was recovered from the conscious position of the accused petitioner. Accused petitioner, full stop. However, no, petitioner, full stop. Further, he submitted that the wife of the present petitioner is 8 months pregnant, and considering the and on the humanity ground also, the accused may be released on bail. However, he will cooperate the IO in further investigation of this case if he is released, if he is allowed to go on bail. Next, Mr. Who submitted an additional PP submitted in this regard that it is a case of NDPS and hence the city will be required to know the actual fact of the case. And accordingly, he insisted to call for the case trial. Next, hearing this submission made by learned counsel for both sides. Other aspects of the case, vis-a-vis the length of detention already undergone by the accused petitioner. I find that the IO got sufficient time for his custodial interrogation, and further custodial interrogation may not be required for the purpose of investigation. Accordingly, I find it a fit case for the where to his satisfaction.
Special just come to Metro, madam.
Special just come to Metro. Okay.
Obligation.
Item 8.
Well, in this case, I was arrested on 26 or 25. I have, it is 5 grams of 85 grams of heroin has been allegedly recovered, madam. And 72 days behind the bar, madam. 72 days. Statutory period is over, madam. Yes, it has been charged.
Oh, then what is the status?
Well, we have filed a bail petition, but it was rejected, madam. Well, in this case, this only submission is that, madam, we will face the trial, madam. That is nothing, and it is in the midst, madam, not a commercial quantity, and moreover, madam, the ground of arrest was not mentioned.
Have you annexed this one? This time?
That I have not annexed, madam.
Oh, see,
That
without
I have
annexure, how can
annexed
you
the
say
forwarding,
verbal
but nothing
submission?
is there. Nothing is there. Forwarding is not there. Nowadays, of course, after the judgment, now they have printed a new thing. They are giving in the forwarding all these things. Arrest memo, they are putting that this is the ground.
No, it's okay. Now you have annexed whether that's what I'm asking.
Forwarding is I have annexed, madam.
No, forwarding is the forwarding will be the ground of arrest will be there forwarding.
That is there. That is not
Still you have
the,
annexed.
that is not the enough, madam.
No, why I'm asking whether we have annexed the 47, 48, these things are annexed.
No,
You have.
that I have not annexed because.
Then how can we say? Otherwise, NDPS as okay, what is if the ground of arrest was not there, then that it would have been a case of bail. But therefore,
That
that
is the
also
ground
you
we
have
have
to.
taken here also. Madam. There also you have submitted, court has not considered. That is the you call for the record, madam, you should get it.
We have to call for, otherwise.
Or I have to obtain the memo of the arrest, madam. It ought to be mentioned in the memo.
The arrest memo as well as 47, 48, if it is available, those are also required. And if case record comes, then it will be available.
You lordship may fix it at 3 o'clock, madam, I will help you.
So lots of matters are there. Let it be after immediately after.
Madam, man, behind the bar, that is.
I know.
You
have not come with any out. Now, see, all for all the cases, it's not possible for in all the cases we have to accommodate. This is not possible for us. We could have annexed the certified
If I
copy
could
also.
bring it by through mail, madam, email, madam, those things, that's why I'm praying that.
You have to file the certified copy.
It's a behavior also then.
Immediately after Bihu on 21st.
Tomorrow?
We don't have any dates.
Any day
We
before,
have
any day
some
before
problem
Bihu,
in
madam,
fact.
any day before Bihu.
We don't have any. That's what I'm saying. At 3, you can bring at 3. Okay, then at 3. 3 p.m. Okay. 3 p.m.
45.
40.
Here on the last occasion, I had raised the ground that this is the case of shown arrest on 11/12/2024. But the notices under 47, 48 and 50, 50A CRPC, those were not served at all. So your lordship was
Yes, this matter was looking after by Mr.
Mr. Kangan. Kangan, yes.
Yes, he was looking after
Yes.
this one.
So after
Whether
some
he
time-
is available?
Yes, available. Another court. After some time, we'll call him.
Because I have some, I don't know, that
Uh,
may be correct or not, but
Regarding that,
while shown arrest,
Yes, yes.
these are not required.
Yeah,
Because on the basis of the case diary, only the order will pass and accordingly the forwarding report will be served to the other
in
side.
fact, I have two judgments passed by this honorable court,
Okay,
where the court has said that irrespective of shown arrest or arrest, you have to show the grounds of arrest.
so where from it has gone? Is there any authority in that regard?
Authority has not been stated, but
Is discussed any authority?
yes, the shown arrest thing is there. When mentioned at para. Para para 5, your lordship.
Para
the
5.
Para 5 of this judgment, the present petitioner was intercepted on 15/9/2024 at Patharkandi by
What are reading? This
This-
order?
Yes, yes, Mahfuzul.
What?
Mahfuzul Islam. This order, para 5,
Mahfuzul Islam, para 5.
para 5. The present petitioner was intercepted
Hmm.
on 15/9/24 at Patharkandi by so and so, while the petitioner was on the way from Badarpur to his residence in Tripura along with his friend so and so in a Scorpio vehicle. Accordingly, the petitioner was arrested on 16/9/2024 in connection with Bazarichera PS case number 90 of 2024. This was the first time when he was arrested. Subsequently, on 3/10/2024, the IO of the present case submitted application before the session judge for passing an order for making shown arrest of the person, along with two other accused person on the ground that as per the statement of the accused person, it was revealed that the present petitioner and two accused were the agents who had passed the POCSO from Assam to Tripura to Churaibari gate since long. Accordingly, the petitioner has been shown arrested in connection with special. So this is the second case where he has been shown arrested. And later at paragraph 7, the learned counsel for the petitioner further stressed his argument on the point that the petitioner was shown arrested in 410, but no grounds were communicated to the petitioner in the notice served upon him under section 50. So accordingly, citing the judgments of Vihan and Prabir Purkashta, the court has granted bail at page 14.
At page?
Para 14. On a bare look at the aforesaid provisions, it reveals that the aforesaid provision provides certain safeguards regarding arrest and detention. It aims to protect the rights and liberty of the individuals who are arrested or detained by the authorities. It ensures no person can be arrested or detained without being informed of the grounds for such arrest or detention. They have the right to know the reasons behind their arrest, enabling them to effectively exercise their legal rights. Thereafter, para 17, in the aforesaid case, it was observed that when an arrested person is produced, this is important, is produced before a magistrate for remand, it is the duty of the magistrate to ascertain whether compliance with Article 22(1) has been made. The reason is due to non-compliance, the arrest is rendered illegal. Therefore, the arrestee cannot be remanded after the arrest is rendered illegal. It is the obligation of all the courts to uphold the fundamental rights. And thereafter, at para 20, proceeding to the case in hand, it is reflected that notice under 50 CRPC was served to the petitioner on 410 in connection with the Bazarichara PS case number so and so. This is the notice which reads as follows. From the aforesaid.
No, it is from Bazarichara.
Bazarichara. Earlier, he was in the present case, he was arrested in regard to Bazarichara PS case 90 of 24. Then later he was shown arrested on 4/10/24.
You're saying that in the time of shown arrest also, he was served with a section.
No, he was
50 CRPC.
although he was served with a notice, but the grounds was
No, whatever. He was served with a notice.
Yes.
Okay, then that's Mr. Das.
I will call him after some time.
And then there is another case in Joinul Hussain. Here also same thing. Shown arrest thing has been issued. Here precisely paragraph 4. In that regard, by filing an additional affidavit on 21/3/25, the petitioners placed before the court the notice
So
issued.
do you have anything to submit before us?
Uh,
Now,
here-
and the last case, you
Yes.
have submitted 150 CRPC. Here, do you have anything?
No, here my case is that I was not at all served with a notice before my shown arrest. Therefore, I could not bring the documents on record because I made an inquiry with the dealing counsel there. He said he checked through the entire records. There is no arrest memo or notice available on record. So therefore, on a prayer made by the IO before the learned sessions judge, the session judge has allowed the shown arrest prayer.
No, we see that is the procedure.
So without serving a notice, independent notice on me.
Okay.
After some time, let him appear before.
Mr. Das,
Oh, Das.
where is he?
He's another court, Lordship. We are informing him, Lordship.
Okay, he was asked to make some inquiry. in
Yes,
that.
yes, yes.
So he may be there. I'll just pass. And to other matters, you just try to get detail.
In regard to those matters, I have only got the certified copy of the arrest memo. Therefore, it may be fixed immediately after vacation. 2 and 3, item 2 and 3. The records can be called for.
In the
because
meantime,
charge
record
sheet
can be
is-
called for.
Yes. Both are charge sheet.
2 and 3 corridor. Immediately after vacation. You want any fixed date here?
20 to 23. As per your lordship.
223, lots of matters are there, I think.
Then
25
24.
and 5. Many. 28 will be too long for you?
28.
Huh?
Little bit before that. 1 or 2 days. 26.
26 is a holiday, I think.
Holiday. Then 20.
25, okay. 25, okay. This matter will take enough, Mr. Das.
Obliged.
Item 9.
Forty. Item 2 and 3, compulsion. 25 for Hussein. Or A2 for timing us. Order 40, item number 45. You're on item number
9.
9.
May I view?
Yes.
This is anticipatory bail application, Your Worship. The FIR is at page 12. May I read it?
Yes.
With due respect, I would like to inform you that today I was on night patrol duty under the said police station together with my accompanying battalion staff dated 4 to 25 when I heard from a confidential source that in the Renault type driver vehicle by number these illegal cows were deported from Jorhat and coming towards Nagaon and therefore imposed a Naga checking before the said police station and during the time of checking when we tried to stop by giving signal, the driver of the said vehicle drove the vehicle at a high speed by breaking the signal and we chased the said vehicle. Suddenly the said vehicle lost balance and hit the bridge. We tried to arrest the occupants of the vehicle, but the man fled away, leaving the vehicle and the stolen cattle, taking advantage of the darkness. After searching the vehicle, we recovered the 3 cows and 2 calves and brought 5 cows along with the vehicle and handed over the vehicle along with the cows to the officer in charge of the station. Now, Lordship, in the petitioner hearing is not the accused, named accused in this FIR, nor he is the owner of the car, nor he was involved in this incident or was even present in that situation, in that place of occurrence. But the police has been continuously searching for him under some wrong identity, coming to his house every day, and people are being arrested randomly in this case under some suspicions that they are being involved. So they are trying to, their parents of the petitioner has been trying to convince the police that he is not being involved in this case. He is not the owner of the car nor of the cows, nowhere. But he has been continually searched in his house every day. So he may be given an opportunity to record his statement before the IO, till the city council also.
Why he is apprehending arrest?
That is the reason why he is apprehending. Every day police have been visiting his house. He is not being able to be there. He is in the fear of getting arrested because people are randomly being arrested in this case by the police under suspicion. Because nobody is, some accused person fled away. We are not denying the fact this didn't happen. It may happen, but he is not involved in this.
Whether
He
he
may be
is
given an
involved or
opportunity,
not,
what
that
is
is
it?
will reflect after going to the case diary.
If anything comes against him, then he is anticipatory bail may be vacated, interim may be vacated. He may be given an opportunity till then.
So, Mr.
Yes, Ahmed.
Heard Mr. Asami Dilane counsel for the petition. And also heard Mr. D. Gusami Dilane additional PP appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. It is submitted by Mr. Ahmed that next paragraph, it is submitted by Mr. Ahmed that the present petitioner is innocent and he is no way connected in the against offense. He is not the owner of the car, nor he is a purchaser of the cattle which were recovered from the vehicle, nor he was present at the time of alleged incident. However, the police is searching for him for some wrong identity, and hence he has an apprehension of being arrested in connection with this case. However, he is ready and willing to cooperate with IO in further investigation of this case if he is granted with some sort of interim protection. Next paragraph, Mr. Goswami Dilane additional PP submitted in this regard that the perusal of the case there will be necessary to know the facts of the case or the involvement of the present petition. Next paragraph, uploading the submission made by London Council for both sides, considering the aspects of the case, I find that one chance may be given to the present petitioner to appear before IO and to cooperate in the investigation of this case, accordingly provided for. Okay, will be under interim protection, appear before the IO within 7 days. Yes, doctor. Any date for the month of May? Month of May, you can give.
Lordship. 7th of May, 7/5.
Abide by all conditions.
What's over?
Item 10.
Not legal, okay. Lordship, basically the FIR is of 498A, Lordship. The entire allegation is against the husband, Lordship, due to his first wife, Lordship. The entire allegation against the husband, and the husband was granted bail by your Lordship. That Lordship, you can see the order on page 27, Lordship. This is the order the husband granting anticipatory bail by this honorable court, and thereafter interim was granted, thereafter absolute bail was granted by this honorable court. And the petitioner before your Lordship are two married sister of the husband, and one is nice, Lordship. And they are three of the persons are residing separately, two in one in Madhya Pradesh, one in Rajasthan, and another one is Tinsukia, Lordship. After marriage, Lordship, they were residing separately. Lordship, would you like to go to the FI, Lordship?
No, against them, what is the allegation?
Nothing allegation, only one line is there that they assaulted, only one line, Lordship. The entire FIR is against the husband, Lordship. Her allegation is that he married earlier, Lordship, and suppressed the fact regarding his first marriage at the time of their marriage, Lordship. And assault and everything is done by the husband, Lordship, that has been alleged in the FIR. If Lordship wants to go to FIR, Lordship, but the husband is granted anticipated bail. His bail was made absolutely.
Page 17 is the FIR.
FIR, Lordship. 8 is the we are named in FIR, but these persons are named in the FIR. 3 ladies there, they are named in the FIR.
Yes, Mr. Okay.
Many allegation against the husband and they are associates as per the FIR. So let him appear before IO.
Heard Mr. H. Mani, Dilane counsel for the petition. Also, heard Mr. D.P. Kusami, the learned additional PP, appearing on behalf of state respondent. Okay, legal, this is an application, acceptance, soon connection. Next one, Mr. Munir, the learned counsel for this petition is submitted in this regard. That the present accused petitioners are no longer connected in the earliest reference. Only allegation brought against the present petition that they were also, as they also assaulted the victim. However, all these petitioners are residing in separately in other place, and they are not at all connected in the earliest reference. However, they are ready and ready to go to one. Or take it on the insist to call for the case study. Okay, you'll be a late.
9-5.
But cooperate in the investigation, appear before the IO.
Much obliged. Much.
11,
Make business with Lordship. Lordship is 482 application Lordship.
Oh.
FIR is at page 10 Lordship. And the petitioner is not the name accused in this FIR Lordship. And because he is a grocery shop owner, he purchases and sells rice and other items. So accordingly, he had sent with proper invoice and all. And the co-accused who was supposed to purchase that, who was sent from Dhubri, that goods, already being granted bail by the learned Sessions Court Lordship.
You purchase the rice, or you are the.
Actually, I'm the seller Lordship, and I purchase the goods where I purchase from various traders, farmers. And my shop is there at Dhubri Lordship, Alam. So I sold, there was a requirement, so I sold to a vendor here in Guwahati with proper invoice and all. And that truck was, those goods which was being sold, that truck was being kept and.
So have you annexed any these things, your business, you're dealing with the business or those invoices, etc. Have you annexed?
No, neither. No, it's mentioned in the FIR Lordship. I'm the owner of Afrin Store, Messrs. Afrin Store, which is there at page 14 Lordship. It's mentioned in the FIR.
No, you may be the but your.
I understood, Lordship, my
Yes.
credentials.
Hmm.
At 2 o'clock, we will submit.
No, not possible to.
We can call for a case diary because whether his involvement is there or cheap, it's not a case diary because the rice is the PDS rice or not.
Lordship,
That should be ascertained. Whether it is, if it is PDS rice, then their involvement.
My-
There.
I purchase from various farmers and various individuals, also those who comes with quintals of rice, 1 or 2 quintals, I purchase from them also. And then I go to the market, and then from there also I purchase rice, Lordship.
So who purchased from you then?
I have sold 200 to 40 bags of rice to a vendor here in Guwahati. And that person is being granted bail by the learned Sessions Court Lordship, which I have given that on. So I have.
That is the crux of the case. The
Lordship,
purchaser who purchased these 240 bags, he may be a genuine purchaser, then showing all these things, most probably he purchased.
I have.
But where from you have collected those 240 bags? That is missing, and you have not placed it anything. And you're saying that you are a business trader, you.
Yes, but my
purchase.
credentials I
Yes,
have not
yes.
annexed. Lordship, if I am granted one day also time, or at 2 o'clock, I can produce all my credentials. Lordship,
We don't have any date, because it is a prior view, we don't have any dates. That is the main problem it has.
I humbly pray, Lordship. And most of the section is 2 years or 3 years.
That is
of
understood.
punishment.
From where from you have
Lord-
collected these rice, that is the questionable.
Lordship.
The other
which
one,
I-
he is a purchaser, he got bill.
From farmers and all, Lordship, which I have stated in my petition,
Okay,
Lordship.
so let it be on 21st April. You are not in custody, you are.
Yes,
APS?
it's an anticipatory bail, Lordship.
Yes.
So I humbly pray for at least for a protection, Lordship. I will cooperate with the investigation,
Now,
Lordship.
if I have anything to hear that we could have grant you, but there's nothing. where from you purchase, there's nothing, because there's allegation is that it may be suspected to be PDS rights.
Yeah.
The other person he purchased from you,
Like,
that is understood.
usually PDS rights are directly given to the beneficiaries.
That
Lordship.
is
It's
things
true,
are going on.
There is a system through their fingerprint only. Beneficiaries can only receive the PDS rights.
These are all, these are made, but if it is could be followed, then it was okay, but.
Lordship, I'm nowhere connected with that. I have purchased the
You
rights
are
from
connected. You're from your shop only at this point.
Lordship, I
That's
have,
why I
if
just-
if I am protected, Lordship, I'll cooperate with the investigation, Lordship. I will produce all the documents, Lordship.
Now, we don't have any documents from before us. That is the question. And we don't
I-
have any
I-
days before we, sorry, very sorry, we don't have any. Either maybe at this 21st, reopening day, on the day of reopening. In the meantime, we'll call for the also, you also praise through an additional affidavit, you can annex all the documents. That is the issue.
Before vacation, is it
We
possible,
don't have,
Lordship?
we don't have any.
Or today only at 2 o'clock also I can
2
produce.
o'clock, so there are many matters have been already been fixed at 2 o'clock. That apart, I have a matter from Arunachal also at 2 o'clock through VC. We don't have. That is the issue. 21st, we are giving just reopening day.
Dispute them.
See the call for review.
Item 12.
Wait, please, your lordship. Lordship, this is an anticipatory bail application. Lordship will find the FIR on page 16, lordship.
Page?
Page 16, lordship. Cases though, lordship, registered under 303, lordship, that's a theft. And under Special Act 7 of the Commodity, Special Commodity Act, lordship, and the petroleum. And that Special Act, both the Special Act is available one, lordship. Now regarding 303, lordship, that is a theft, lordship. There is no allegation from any part of the any victim, lordship. They have lodged any allegation that these items are stolen property. It is the FIR lodged by the police, lordship. The FIR lordship will find on page 16, lordship. What happened, lordship? This petitioner is a cultivator. He along with his siblings are doing, lordship, having a tractor and 13 numbers of diesel pump set that is installed in the paddy field, lordship. For that, lordship, we record lordship diesel. That's why, lordship, will store some diesel for our own use, lordship. But that has been projected as a stolen item. But nobody has complained, lordship, these items were stolen, lordship. Moreover, lordship, if they go through the lordship FIR, lordship will find they stated 4 numbers of drums suspected to be diesel, blue color. Per drum capacity is 200 liters. But they have not stated, lordship, how much they have recovered from me, lordship. Drum may be, lordship, having capacity.
Caesar, you have next.
Lordship, Caesar is there. This Caesar. They are mentioned about the capacity of the drum, lordship. I have annexed, lordship, all the pumps, tractors owner registration certificate as well as, lordship, the pump set number. Those who are installed in my paddy field, lordship. In my petition also, lordship, I have stated in para 4 in page 6, lordship.
But as per the Caesar list,
that is
four numbers of drum with diesel.
Capacity, lordship, capacity, per capacity. They have not said, lordship, how much is their diesel in that drum, lordship. That is not stated, lordship. A bottle may have, lordship, 1 liter capacity, but it should contain what exactly is there.
Hey, Mr. Goswami, hello.
Capacity to the capacity
No capacity.
per drum capacity 200 liters. So
no, per gram capacity 200 liters, but here
drums,
it is not clear from the Caesar whether the capacity is written there or entire drum with 200 liters were been seized. That is not there.
4 numbers of drum with diesel. Per drum diesel 200 liters. Capacity. Not written in capacity. In the FIR it is written capacity. But in the Caesar per drum diesel 200 liters. Here. It is your copy. But in the Caesar list per drum diesel 200 not in capacity is there. In the FIR.
No, FIR capacity.
Yes,
diesel.
but they have to mention, lordship, how much they have seized.
200.
Even
as per the Caesar list 200.
Then, lordship, even they have registered the case under bailable offence, lordship. 23A, lordship. 23A is a bailable offence, lordship. Now I am regarding theft, that is not there, lordship.
But from where it has come?
Lordship, the diesel said, Lordship, I have annexed all that, Lordship, tractor registration certificate as well as the pump set, Lordship, we have installed in our land, Lordship. That all numbers are there that contain from page, Lordship, 22 onwards, Lordship. FR is itself, their FR, Lordship, they have certain its capacity, Lordship. That FR was not lost by any individual, Lordship.
But you have so many parcels receipt, you have purchased it.
That I have already installed, I have stated, Lordship, who these villagers, Lordship. (23)A, Lordship, shall be punished with simple imprisonment which may extend to 1 month or with fine which may extend to 1,000 rupees or both. There's a Petroleum Act 1934, Lordship.
That is true, but regarding 303, where he has taken these articles from where it has stolen or not, that should be ascertained.
The individual, there must be some victim, Lordship, whose material has been stolen. They have to lodge the complaint before the Lordship police station. That is not done, Lordship. It is because of this police, Lordship, they have some vested person might have misled the police by saying that I have a cultivated land that I have stated, Lordship. Tractor I have shown, Lordship, that required, Lordship, diesel and pump set that is still installed in my land, Lordship. They can search, Lordship, whether this is correct or not. Let me appear, Lordship, record my statement, Lordship. 2 of my brothers already arrested, Lordship. I filed bail application for them also, Lordship. Probably it will come tomorrow or day after tomorrow.
Pardon, Mr. B. Chaudhary, the learned counsel for the petition. Also had Mr. D.P. Goswami, the learned additional briefing on behalf of state respondent. It's an application under section 17 in connection with 17. Next, right, submitted by Mr. Chaudhary that the counsel for the petitioner that he is innocent and no way connected in the LS offense. It is the fact that some diesels were stored in his house only for the purpose of using them for the tractor as well as for the pump set which were installed in his benefit. He further submitted that there is no ingredients to fulfill. There is no ingredients to fulfill section 303 of subsection 2 BNS, as there is no complaint from anyone regarding any theft of diesel from theft of diesel first. However, he is ready and willing to cooperate the I and so and so. Mr. Goswami, the learned additional PP submitted in this regard that there is no document to prove as to where from he collected the or purchased the diesel which were seized from the house of the present petitioner. Accordingly, he submitted that CD will be required to know the actual fact of the case. That's a packaging demand. Okay, you will be under interim protection.
Highly obliged.
8 of May, 8/5.
Highly obliged.
Bill hearing item 16.
May I please, Lordship. So this is commercial quantities recovered, Lordship. And Lordship, more than one year, 4 months, some days, Lordship, with custody.
Will kindly pay us the office note dated 7/3/25.
Yes.
By order dated 27/1/25, up to date records were called for Lordship. And as per office note 70/25, it has not been received.
And to my one submission, Lordship, the petitioner was arrested 23/11/2023, more than 1 year, Lordship, but they are in custody. And charge sheet was filed in time, Lordship, within 179 days, Lordship. But till today, Lordship, charge perhaps not fair, Lordship.
Why? What is the reason?
I don't know, Lordship. There is nothing but 2 accused, Lordship, they are in custody, Lordship.
2 accused are in custody.
See,
And
the date
CS
of
was filed as per you?
179 days.
No. CS was filed.
Fine.
Charge sheet was filed when?
Fine, Lordship, and Exact, I have not, cannot say, but 100 arrested on lordship 23/11/2023.
Yes.
And seized their lordship within 179 days. That means lordship, within time lordship. In the year
Charge
of
sheet was filed within that.
lordship. So this
But I don't know, we don't know why it is, whether it is or why it is not.
Let the records come, Lordship. The
Record
up-to-date
has to
records
come.
come.
Up-to-date record was in fact called for
Yes.
lordship, lordship.
by Justice Foucault on 27 of
Lordship.
2020.
It will come, Lordship.
Let it be awaited, then it will be obviously after Bihu, we don't
Lordship,
have any
lordship,
alternative.
lordship.
Yes, when it can. 29/4 will
Lordship,
do.
lordship.
Lordship, in-
Updated case diary be called for. Registry will do the needful, yes.
Lordship, in
Obliged, lordship.
in respect of item 27 and 28, Lordship had directed me to take
29.
instruction whether charge sheet has been filed or not.
Item,
27, 28,
yes,
charge sheet has been filed, Lordship.
CS file.
Yeah.
Can you tell us the
Yes,
number?
yes, CS number 12/25, dated,
CS 12/25,
dated 28,
28/02.
25.
In both the matters, because out of same affair,
Same, yes, yes, yes.
you are behind the bars in 61 days.
61 days.
Same order with the appropriate application for bill that may be considered. We'll pass the order and we'll also mention the time of the period of detention also, 61 days.
And I may be directed to. appear.
Yes, yes, both bill.
No, it is not 61 days, Lordship. It was,
61 days.
Aji hai?
Today is 61 days.
It was filed on 28 February, Lordship. Charge sheet was filed on 28
No,
February.
no, we are not on that. He is behind the.
Oh,
He is
I'm sorry.
behind you from 6-2. It is 61 days.
Oh.
Right?
Okay, we'll
Objection
part-
maybe.
Yes, yes, definitely. 61.
Development.
17.
Lordship, here in this case, my lord, charge sheeted matter, my lord, NDPS matter.
Also, but time
You need some time.
Mr. Care is coming.
Okay, for some time.
18.
There also, Lordship will kindly peruse office note dated 29/3/25.
May I please? Lordship?
Updated one is not received.
Yes.
Your petitioner is behind the bar since
My
when?
lord, 2.5 years, my lord. Long detention, my lord.
Yeah, obviously, but
Delayed
we
it.
need something.
Yes, yes.
Since when it can be.
After relocation, Lordship.
After revocation, registry will call for the default.
My lord,
Updated.
21st, my lord.
21st may not be possible, may not be possible. Some urgent matter we have, your petitioner is in bar, definitely I can understand. But still, 28 or 29 maybe. Either 28 or 29 of April. 28? 28 of April will give him. Still will do the needful. We are asking registry to call for the updated reminder. Issue reminder.
Oh, yes.
19.
My lord, in this case, my lord,
There also, Lordship, office note dated 10/3/25.
my lord, in this case, my lord, what happened, my lord? Last one, my lord, 1st April, my lord, main accused, my lord, this granted bail, my lord. Main accused, my lord. Your Honor, in this, my lord, there are the 4 accused, my lord. Number 1, accused, Manish Kumar, my lord. Manish Kumar granted bail, my lord. By honorable this court, my lord, last 1st April, my lord.
Out of same FIR. It's a
Same,
co-
same, my lord, same.
There they have also taken the
No,
ground
accused
of,
number 1, my lord, that is Manish Kumar. Manish Kumar granted bail, my lord.
no, they have also taken the ground of this arrest. Do you have anything?
No, the delay in trial was, my lord, 2 years, 5 months completed, my lord,
No,
behind the
that
bar.
is
My lord,
there.
trial is
That is there. Apart from that, they have also taken the plea of non-furnishing of this arrest, ground of arrest. And here you have taken this ground? No.
No. Then I will file my lord additional affidavit that by the,
No, we don't have any date.
my lord, after my view, my lord, I will file my lord additional affidavit by annexing the non-grounds of the
And
arrest.
what is the instructions we have as till now? How many?
Yes, my
people
lord,
there?
same condition, my lord. They are 4 accused person, my lord. Same time, same day, my lord, they are arrested, my lord, without arrest memo, my lord.
Records are not updated, Lordship, but to my instruction, 3 PWs have been examined.
Yes.
Out of?
Out of 8. But it was way long back, Lordship, the records are not.
No, but
updated.
last occasion, we have produced the case record, in fact, 1/4. When you have seen that 4 numbers of witnesses were being examined.
Yes, my lord, yes.
Yes.
That is
Out of 8 men.
out of 8 numbers. Okay. Okay, then parity can be considered, I think, because
Lordship.
I don't think 1/4 the order was passed. And today is on, it may not be there any order.
Lordship.
I heard Mr. S. Rahman, the learned counsel for the petitioner. And also heard Mr. B. Sharma, the learned additional PP, appeared on behalf of state respondent. And this is an application under section so and so in connection with so and so. It is submitted by Mr. Rahman, the learned counsel for the petitioner, that present accused petitioner is innocent. And he is no way connected in the LS document. First of nothing has been seized from the conscious position of the present accused petitioner. And he further submitted that the accused petitioner is behind the bar since when?
2 years, 4 months, 8 days.
Since 2 years, 4 months, 8 days. But till that the prosecution could examine only 4 numbers of witnesses out of 8 numbers of witnesses. And hence the probability of completion of the trial within a very short period is also cannot be expected by the power. Yeah, same technical, same nothing. Out of submission, he further submitted that the co-accused, one co-accused, namely Manish Kumar, has already granted bail by this court on 1/4/2025, considering the period of long incarceration and considering the petitioner on the same footing. The present petitioner also may be granted with bail on the ground of parity. Baki he relied on Baki same table, but don't bring Bihan Kumar and all. Only on the length of detention, incarceration. Don't bring Bihan Kumar. This plea is not here effect.
Obliged.
The order is already here. Okay.
This is a lordship. In this case, I was arrested on 11/6/2023, Malad. I'm a driver by profession, Malad, and on the arrest day of occurrence, Malad, may I just take a lordship FIR, Malad, which is at
11/6.
Yes, Malad, 11/6/23. Page 11 is the FIR, Malad. On that arrest day, Malad, the vehicle was the truck was stopped by the Naka checking party, and from there, Malad, 6 cartons of cough syrup were recovered. Now, just I'll request the lordship to pay with page 12, Malad. There, lordship will find a serial number 4, Malad, the things which we are seized. Lordship will find serial number 4, Malad, 4, page 12. One tax invoice of Measures New Seema Medicos, so Mandir, Guwahati, Assam, and the consignee details is also there. Ganpati Medical Hall. These goods were, Malad, booked by the New Seema Medicos company. There with their all the documents, and the consignee details are also there. And thereafter, my lord, in this case, charge sheet was laid only against the present petitioner. Lordship will find on 30/9/2023, page 18 is the charge sheet.
Charge sheet was laid only against this petitioner.
Exactly, only against this present petitioner. It was laid on 30/9/2023, citing 9 witnesses, my lord. And charges were thereafter, my lord, charges were framed on 11/1/2024. And till date, my lord, my instructions records are up to till 11/2/2025. No witness has been examined, my lord. And now it has been posted, my lord, on 3/6/2025 for recording of evidence.
How many witnesses you have?
9 witnesses, my lord.
No one examined.
No one examined. Just now also I have taken instruction from the council, my lord, who is conducting the trial. In fact, it was posted on 26/3, then also my lord, no witnesses examined. Now it is posted on 3/6/2025. So my lord, considering this prolonged incarceration, he's already been in custody for 1 year, 9 months, 27 days, as on today, my lord. 666 days. And in the records also, lordship will find, my lord, I was issued with a notice, my lord, that I have marked the same with a blue color flag mark, my lord, trial court record. It is there, my lord.
Chairperson.
Lordship has got it, my lord, notice. There, nothing has been stated. For what, under what grounds, my lord, he has been taken into custody. So, on considering these two aspects, lordship may kindly consider my prayer, my lord, at this stage.
Your petitioner naming?
Santosh Pal. Only one accused person, my lord.
Yes, sure.
On the ground of the information is only provided in the grounds of error. And also I have nothing else to say because that is mandated.
In the site and ground, sir. Arrested on 11/6/2022. He is only the driver of the vehicle and not aware about the loading of any contraband. Further, the tax invoices were also seized from the truck. And truck, however, the charge it was filed against the accused petitioner. And charge is also framed accordingly on 11/1/2024. But till date, there is no till date the prosecution failed to examine none of the witnesses, though 9 numbers of witnesses are already been listed in the charge sheet. If further submitted that on the last date, that is on 26/3/2025, the evidence case was fixed for evidence, but till date, no evidence could be recorded by the prosecution, and next date is fixed on 3/6/2025. Thus, even after his custody for last more than 1 year, 4 months.
1 year, 9 months.
1 year, 9 months, the prosecution could not examine any witnesses. And hence, considering his long period of incarceration, again, the given. Further, arrest memo 9. Arrest memo 9 for 50 CRPC. Sharma submission that there are sufficient, considering the materials available in the case diary, the charge sheet was filed against the present accused petitioner. And he further submitted that there may not be any ground of arrest available in the case record, ground of arrest available in the arrest memo or the notice under 50 CRPC, but the petitioner was well aware about the allegation brought against him, and in the forwarding report, the same has been already mentioned. Accordingly, submitted, considering the so and so. The other is one is labeled in the power report. Scan copy to Anisha. Scan copy of the this is also from Karimganj.
Karimganj, madam.
Evidence report. No evidence. Did you got it? Will be allowed to go on bail on satisfaction to special just Karimganj.
Correct. Deputy.
Well, we have also filed an additional affidavit in this case regarding the non-compliance of the 4748 minor. And state also filed an affidavit. Additional affidavit, Lordship can see, page 35 and 36. Because
$35, you're saying?
yes, page number 35, madam. Additional affidavit, madam.
To public prosecutor. Is it filed by public prosecutor? Yeah. Okay, one of them. Additional PP has filed affidavit on 2/4.
Yes, Lordship. We have filed
And
on
your affidavit on?
17/3.
Oh, yes. I thought the other one is yours. Anyway, 35 and 36.
Yes, ma'am. No grounds of arrest, ma'am.
Yes, it's still under investigation, I think.
Yes, Lordship.
So what you have submitted through your additional affidavit?
It has been
State?
filed by the IO. IO was directed, Lordship.
Iowa's?
Directed to file an affidavit. Lordship.
He simply said that it has been,
He simply
notice has been given, but there are no grounds of arrest, ma'am.
Oh,
That is all.
so they have, in pursuant to that, they have filed this affidavit.
Yes.
Yes.
See, there are no,
Yes.
although the case is most probably still under investigation, 22C matter.
Also, the FSA report is still available.
Now, 103 days where your petitioner got arrested on when?
3/12/24, Lordship, if I'm not wrong.
27/12.
27/12.
On the basis of a statement of the co-accused, madam. Only on the basis of a one phone call, madam, CDR report, as per the. But it's not been, the grounds of arrest is apparently not being complied.
No, I'm just searching for a date because 2-3 matters I have already sent to home the actual department.
Madam.
For this kind of, that's why I was asked when he got arrested. Most probably it was there and I was first order was passed, most probably on first.
Madam, I was, my forwarding, Lordship will find in the petition, page 25, madam. Starts from page 23, madam.
27/12.
27/12.
Mr. A.M. Borrell is senior counsel advocate assisted by Mr. Nawaz. Mr. S. Nawaz, senior counsel petition. Also heard Mr. B. Sharma, the Learned Edition PP, appearing on behalf of state respondent. An application, the section so and so, in connection with so and so. Here you have received a CD or?
Yes, CD has been received.
CD received, where is received? Next private submitted by Mr. Cora, the Learned Senior Advocate, that the present accused petitioner was arrested on 12/12/24, 27/12, so and so. And 12 so and so, only on the basis of a post statement made by, only on the basis of a post statement. Sorry, only on the basis of the statement made by a co-accused, which is not admissible in the law as ratio laid down so and so. Further, he submitted that the clause 2, 35, 36 number 2 from here annex for us through an additional affidavit, submitted the true and additional affidavit. The petition has also filed the notice issued under section 47 and 48 BNSS, wherein the grounds of arrest were not mentioned. Mr. Sharma's submission, Mr. Sharma, the Learned Edition PP submitted in this regard that there are sufficient limiting notice in the case diary. However, it is, and the in pursuant to order dated 2/4/2025, an additional affidavit has also been filed. Additional affidavit has also been filed by the state respondent. However, it is the fact that the ground of arrest was not been mentioned in the notices issued under section 47 of the 48 BNSS. Okay, under whose under whose Kachar or Karim Kachar? Silchar Kachar. Silchar Kachar.
Problem.
22.
This regular dedication, madam. Behind the madam, 61 days, madam.
61 days.
61 days.
Yes.
The last occasion, madam, Lottery was directed upon service of notice, madam, just number 2, madam.
It has been served, Lordship.
Yes, because notices were not there. That's why I was asked to.
Madam.
Yes, what is the report, Mr. Das? Sharma?
It has been served, Lordship. Otherwise, Lordship, you kindly go to the 182 statement of the victim. The entire allegation is against one of the co-accused, Lordship.
Bolin Chandra Gogoi.
Bolin Chandra Gogoi. The allegation is that Bolin Chandra Gogoi has forwarded some obscene photographs of the victim girl to these two petitioners, Lordship. So that is the allegation against these two petitioners, Lordship.
He had the love relationship with
Yes,
Bolin Chandra.
with Bolin Gogoi. Considering the fact that they are behind the bars for 61 days.
Please. Next one, please. 12, madam. Assamese person, madam. Class 12 student, madam. That is FIR, my lord, page 12. Next one, my lord. It is clearly said, my lord, last about 2 lines, my lord, Bolin Somna Gugwe and his friend are involved, my lord.
Your petitioner is Nitul Gogol.
Nitul Gugwe, my lord.
And?
And my lord, number 3, my lord, Francis Burglary.
Francis Burglary. Two petitioners are there.
Francis Burglary, my lord, and Nitul Gugwe. 3 and 5.
Short. Mr. Das?
HP new.
HP?
New.
Watch. Heard Mr. HP now, Delaney Council of the Petition. And also heard Mr. B. Sharma, Delaney Additional PP, appearing on behalf of State Respondent. This is an application under section so and so in connection with so and so. Did he receive? Where is the same? 100%. It is submitted by Mr. Neo, Delaney Council for the Petitioner, that these two petitioners are innocent and no way involved in the alleged offense. They did not circulate in the video as alleged in the FIR. They got arrested in connection with this case only they are the friend of the named prime accused, Sipulin Chandra Gogol. For the case, petitioners are behind the person's last 61 days, and hence, considering their period of detention, they may be released on bail. However, they will extend their cooperation on the further investigation of this case if they are granted with the privilege of bail. Next paragraph, Mr. Sharma, the learned edition PP submitted in this report that considering the materials available in the case diary, especially the statement made by the victim under section 183 CRPC and period of detention, the bail petition prayer for these petitions may be considered. Next paragraph. During this submission made by learned counsel for both sides, I have also perused the case diary, especially the statement made by the victim under section 183 CRPC. Considering the materials available in the case diary and the length of detention already undergone by these two petitioners, I find that further custodial interrogation may not be necessary for the interest of the investigation. Did you go well? To whose satisfaction these things? To whose satisfaction?
But the special judge Soradio. Soradio.
Soradio Sunari.
Special judge Soradio Sunari.
And the special judge Soradio Sunari. Okay.
On the note.
Three.
In this case, my lord, I am seeking bail on count of arrest procedure and also, my lord, the protected underneath the supervisory judgment. Well, additional affidavit filed, my lord, on last 5th, my lord. This is one of the record. That I have.
You have filed additional affidavit?
Yes, madam. This is the acknowledgement received and additional affidavit.
In morning hours, you could have requested this one.
So, my lord, matter may fixed it to my lord by this time, my lord, I'll bring the best on record. Already I filed my lord 2 days back. By
Morning hours, you could have made a prayer, we could have requisitioned for the same.
Now I'm giving prayer, my lord, to requisition. I'll pursue, my lord. Bring it on that.
Obliged. Okay. F2, madam.
Yes.
Time being 45.
I was in different court.
Yeah, it's
I
okay.
have asked Lordship, I know the usual procedure is there when they shown arrest is there, Lordship. And if the custody is given, remand is given, Lordship, in another case, then the person is brought before the another magistrate, Lordship. Then the arrest memo and these things are given to them, 47, 48, Lordship. But here in the case, Lordship, custody has not been given. The police IO was allowed to interrogate in the judicial custody of that magistrate, Lordship, earlier magistrate. So it is according to them, it is not needed, Lordship. Since remand is not given, the IO was asked to interrogate in the judicial custody when he was in judicial custody, Lordship. So he was not produced before the another magistrate in whose jurisdiction the another case is registered, Lordship.
So as per you, this one, he was arrested and whose jurisdiction means? Jurisdiction of
In
the
the
same court.
second case has been registered in another court jurisdiction, Lordship.
The second case is under Sessions Court Sribhumi. And the first case will be. First case is relating to sections 61 to 121 to 130 to 109, basically deterring the public servant to do their duty.
So we are on first case or second?
We are in the second case.
First case was for before whom?
That I'm not sure, Your Lordship. Before the judicial magistrate first class, as per the FIR, which I've annexed at page 26.
So here as you have submitted, here the jurisdiction of one sessions court and other one is the magistrate tribunal.
Lordship.
Then in that case?
No, Lordship, here the case is there, Lordship. He has not been given remand. The police custody is not given to this person, Lordship.
No, you are saying that
Yes,
judicial
Lordship.
question, where is the jurisdiction question? It is also.
Judicial magistrate first
Which
class,
district?
Karimganj.
District is?
Karimganj, same district. But the thing is, Your Lordship, the first case was in regard to sections 61 to 121, 132 and all that. Second case is in regard to 22, 21C, 25, 29. Now, does that mean in the second case, before showing me arrest, I need not be given the details and the grounds of arrest? I need not be informed.
Second one, which is pending before session judge is a case of NDPS.
The first
Other one is?
I think that is regard to
Section?
Section 61 to 121 to 132, 109 BNS. Deterring the public servant to do their duty. So
Moreover, Lordship,
that
the order
is
is
the
passed
question.
as per the direction of the magistrate, Lordship.
Will be there only.
No, direction of the magistrate, it was first brought before the magistrate. That is maybe there.
And I have the instruction in the first offense, he has been granted bail. But subsequently here, he has been shown arrested.
Now, I'll pass the order in my chamber, but the question is that I'm just asking him. He is shown arrest. Obviously, at the time of shown arrest, what the police officer do, generally the CD produced. And on basis of this CD, if the materials are there, then prayer for shown arrest may be allowed. And during the other process, but the somebody question is that the person may be behind the bar in connection with some other case. But does it mean that he should not be aware of at under which case he is subsequently shown arrest or forwarded? Can it be? I mean, if you go by the,
No, not.
and in that part, this is the case of 22C, commercial quantity.
Not,
The earlier one was wasted tribal.
not.
So why the IO filed the prayer before the wasted first class? The prayer was made before wasted first class.
As
All
per the,
sessions.
as per the order, I think
before the sessions only.
Before the
this-
sessions, it has to be before the sessions.
Sessions of this,
Before the session, because
Session.
the jurisdiction is of.
Before the session.
which was allowed as per 11-12.
And if you go by the sections also, they're quite different sections.
Different,
One is under
different.
the NDPS section, the
Different.
other one is the other BNSS, some BNS different.
That will be, your lordship, statutory as well as constitutional violation, and the embargo will also not lie under section 37. Because
So here, as per you, this is not a case where the
Uh,
grounds
even
of
the-
arrest were not mentioned, but
even
you
the
are not,
notice was also
not issued.
not issued. There is no physical notice. 50-50. Or else that would have been in the record.
The
And-
record is not before us.
Record is not before us, but as per the learned PP's information, whether the 50-50 notice are available on record in regard to
All as per his information, it's not there.
that information, obviously he can enlighten. And as per my instruction, it is not there.
Not even issued.
No, no. Just that there is a order of shown arrest, formal shown arrest, and from 11-12, I am in judicial custody.
In connection to the other case or this case,
With the second case, NDPS.
11 to 25,
11-12-24. 11-12-24.
in the second case.
In the second case, that is special NDPS case 108 of 2024. And I have submitted the co-accused judgments also, where your lordship has let them out.
Okay, Mr. Das will pass the order.
Obliged.
24 and 25.
Make clear, lordship. Here on the other day, lordship has seen the additional affidavit, lordship, that is on the record. And
Additional-
when we applied for the certified additional affidavit, lordship. Here, lordship, when we
It
applied,
is already tagged with the record.
it's checked with the record. When we applied for the certified copy of the arrest memo, lordship, only one copy was given, that page 22. Therefore, on the other day, I have submitted that there may be other documents which my learned friend can produce from the case diary. So probably case diary received, lordship, that no grounds were communicated either to for the 47 or 48 BNSS, lordship.
You could have annexed only the arrest memo.
Only this certified copy was given to me. Other documents were not given. Therefore, I have paid for calling for the record. lordship. That is received. If they can show that from other documents that grounds of arrest are communicated, then that is a difference.
In the case that it is not only the grounds of 47 is there, but grounds of arrest not shown in it.
The 47 are available or not?
47 is available, but grounds of arrest not shown.
No, that day he was saying that 47 were not provided to him. That's
No,
why-
when I applied for the certified copy, only this document was given.
Yes, yes.
He only
Shown. Oh. Your petitioner's name is?
Nazimuddin.
Another one?
Other AB lots.
Other one is Eddie.
Oh, other one is AB. So basically, since when your petitioner is in custody?
He is in custody since 28/11/2024.
130 days. ago.
That is prior to the order passed by your lordship. That was passed in 8th of January 2025.
Yeah, earlier this one.
Yeah, first one.
Yes, any other submission materials in regard to materials?
Therefore, the Quakers implicated him, right, AB number. He also yet to be arrested, lordship, and FSL report is also positive. FSL received, lordship.
Regarding against the present petitioner, there are
Present petitioner-
materials.
Yes, lordship. Present the ground of arrest is.
Oh, that is there. Otherwise, materials
Otherwise,
are
other
there.
materials are there. She's from his position, lordship. Three persons are there, lordship, at the vehicle. So materials are available. Only thing is the procedural lapse, then
Any submission from your side?
Lordship, regard that, I'm relying on the judgment passed by your lordship.
No, it is 47, 48 is okay. Otherwise, any other submission regarding the materials? Otherwise, you are not taking any other plea regarding the
At this
recovery?
stage, I
and-
am not taking any other plea, lordship. And in AB lordship has already directed to be listed on 29th April, lordship, that anticipatory bail. That order is there, so that may be, that may come upon even, and they may update the case diary also, lordship.
It will kind of do that plea, or you say?
so already the investigation FSL is positive. FSL report is received, lordship, because calling for a case by that's why CS cannot be submitted by the regulars. Otherwise, investigation FSL is positive. And
So after receiving of FSL, why they are waiting?
CD was called for in the meantime, lordship. That's why
Oh,
they have
that's why.
that's why they have produced the case diary for appeal also.
আচ্ছা এটা একটা মতো লিখে দেওয়া আগতে 2024 এই আহমেদ খাটকু সোয়েন্স এখানে লিখিব দীপি গোস্বামী লিখিব হ্যাঁ innocent or লিখি নিয়ে অলপমান and particularly main on the basis of the main ground submitted that he got arrested in connection with 28/11/2024 আৰু there is no mention of ground of arrest in the arrest memo as well as in the notice issued under sections 47 BNS. It's a main ground. Again, likhi diba. Format likhi diba. And as per Goswami, there are sufficient materials against the present petition. Most the recovery was also from his conscious position. And in the same time, the FSL report has already been collected by the IO, which gave the positive test for what was the conduct? Methamphetamine. Again, a submission of liquidity commercial quantities so and so. I mean, to go to it is whose satisfaction this one?
Special just Sribhumi.
Special just Sribhumi. Okay, your petition, this one for 24 is allowed. Now 25, you're an AB. Do one thing, Mr. The otherwise, most probably daily updated quest diary be called for on 29/4. Is it already been fixed on 29?
On the 29. The website back case there.
Yes, 29/4, 29/4. Calling for the updated case diary. Okay, we are fixing it on 29.
All right, lordship.
Go to CDB return.
26.
There are three petitioners in this case, my lord, and all of them were shown arrested in this case, my lord, which I am saying right now, my lord. All of them were shown arrested on 21/25, my lord. So they have been behind the bar in this case, my lord, 77 days. But they were earlier arrested in a different case, my lord. That man 150 days crossing that case, my lord.
Lordship, I have two cases also here, lordship, the name of wildlife forest special is
Oh,
also
that
told.
didn't also.
We are
just waiting for registry to name, reflect the name also.
Yeah,
Name is shown, my lord, shown, my lord.
Acha, Sharma is there. No?
And I have
Sharma, where
also-
is Sharma?
Uh,
He was there in the morning
Yes,
hours.
yes.
Like,
After some time, lordship, I'll just make a telephone call.
just for 5-10 minutes if he comes because he is dealing with the case. I think.
Item 33 also lordship, same affair, lordship.
Item 30.
33 of the same FI.
Yes, same FI.
Same FI.
This is also BA or AB?
BA, both BA.
Just for 5-10 minutes.
27.
29.
Because Sharma's probably-
Lordship, here CD has not been received. The IO has forwarded a prayer, Lordship, taking some time to produce the case.
Lordship, the accused person petitioner is behind the bar since 55 days. It's intermediate
50?
quantity, 55 days, your lordship. She was,
Yes,
I
Sharma,
was-
she is in 55 days.
Let it be on Friday, Lordship.
Friday we are not fixing. Friday.
Friday, Lordship.
Otherwise, is there any instruction that they're going to file the charge sheet within 2, 3, 4
No,
days
no.
or something?
No,
Then
sir.
obviously she is for 55 days, I think.
Lordship, Ganja, Lordship. Sufficient, Lordship. 1 kg.
How many?
1 point something kg of.
1.9 something kg, your lordship.
Just above the small quantity.
Yes, just about.
You are MS?
J Das, your lordship.
Okay, that's such. MS J Das, number 10, the London Council for the petition. And also heard Mr. B. Sharma, the London additional PP, appearing on behalf of state respondent. This is an application under section so and so in connection with so and so. CD not received. No?
CD not received.
CD not received. And it is submitted by Mr. Sharma that DIO sought some more time to furnish the case diary. Next paragraph. MS does submitted in this report that the present petitioner is behind the bar since last 55 days and the contraband which was alleged to have been seized from the possession of the accused petitioner is under intermediate content and it is much below the commercial quantity. Further, she submitted that there was sufficient time for his custody interrogation and hence the further custody interrogation may not be required for the interest of the investigation. However, he is ready and willing to go with you. Mr. Sharma, the learned additional PP submitted in this report that as CD is not available, there may not be, he is not in a position to say much about the materials, much about the materials in the collected by the IO. However, he submitted that the quantity of the cannabis which was seized, alleged to have been seized from the possession of the accused person is just above the small quantity. In the meantime, he submitted that there may not be any probability for filing of the charges within 4 or 5 days by the IO. So next product, considering for the delivery. To whose submission suspicion it is has to be
Kamrup Metro, your lordship.
Kamrup Metro. You have good delivery for you.
Oh, there is nuclear.
30.
30 Lordship, CD has been received, but the FSL report is still awaited.
My pleasure, Lordship. Lordship, intermediate quantity, my lord.
That may be
Petitioner is behind the bar since 44 days. My lord.
is in respect to heroin, Lordship, 31 grams of heroin. So let it be on Friday, Lordship.
My lord, can you
Okay,
see
we're
the
fixing
FIR?
it on Friday.
Friday.
44 days. Huh?
44 days. My lord. Let's see the FIR, my lord, page 10.
Whatever is the intermediate quantity, if we can produce the case diary, otherwise we're fixing it on, where we didn't have fixed any date on Friday, but considering your matter, we're fixing it Friday. That is on 11th, 11/4,
Can it be on 10, my lord?
11 Lordship.
11. CDB call for, we might issue reminder 11/4.
Public.
You take also, Mr. Sharma, you also take instructions on that day. If CD is available, it's okay. And what is the progress of the case, we'll get it.
Okay.
And suppose if it is almost ready, the FSL is also received and matter would have been different, otherwise we'll see.
Lordship.
51.
My pleasure, Lord.
Yes.
Lordship, in this case, CD was called for, CD received, my lord. The learned English council lacks in other court, my lord. It will be fixed on F2, my lord. Family.
FSL we have not received yet. 165 days in custody, Lordship, a commercial quantity case.
Yes, my lord.
22C and 29.
You were in custody since one?
165 days.
Okay, there may be some other ground also, will, for time being.
For the time being, at 2, my lord.
At 2, I cannot say 2 of many matters are there. Anyway, with time being, we have to be it. If it reaches, then reaches.
My lord, this come from.
Oh, yes, come, only, okay. Yes, Mr. Hussain.
My lord, the petitioner was arrested on 24/10/2024.
24/10/2024.
My lord, 165 days ago. No such thing has been filed.
CS not filed.
Petitioner is the driver, my lord. And the other 2 accused persons, they carried the contraband. My lord, the petitioner was supposed to pick up the two accused persons. But while the petitioner came to know that the cartoons are along with the said accused persons, he refused to pick up the persons in the car. Then an altercation took place between the petitioner and the said 2 accused persons, my lord, in the market area, my lord. And then during the altercation, police arrived at the place of occurrence, and the said 2 persons along with the driver, the petitioner, my lord, they have been picked up by police, and thereafter he has been arrested, my lord. Actually, my lord, the allegation is that the cartons were recovered 199 bottles of cigarette, my lord, were recovered from the vehicle, inside of the vehicle, my lord. That is false, my lord. The contraband were recovered in 2 cartons, my lord, nearby the car, not in the car, but because he did not pick up the cartons in his car. And in a market area, my lord, the same assist. So for grounds of arrest, no specific grounds of arrest have been met by the police against the petitioner, my lord. In forwarding report, my lord, grounds of arrest have been shown. The arrested persons are FIR named accused persons. The arrested accused persons are arrested in possession with containing suspected psychotropic substance and accordingly seized as per seizure list. Number 3, sufficient evidence have been found against the arrested accused persons. Altogether, 3 persons were arrested, my lord. So there is no particular allegation against the petitioner, my lord.
There.
But on 24th, the statutory period would be completed of this month, 24th of this month.
Sure, mine it.
There was some materials are there, lots of sufficient materials against the petitioner. He is involving this illegal narcotic business and Coec is also setting that lordship. Otherwise, still waiting for a FSL report.
He's saying that
Any
he-
prayer for ground of arrest that is not showing the arrest memo also.
There is no ground in the arrest memo.
BS 47, 48 is
47,
also
48 notice of the alert.
no ground of arrest.
And as per the IO note, Lordship, he has note here, now I received order copy from Special Judge Gwalpara, extension of investigation period for 1 month. That is the last updation of this case diary. It was 18/3/25. But regarding ground of arrest, that is
And otherwise pray for the extension.
Lordship.
You are Mr.
Jason.
James. What to do?
Ground of arrest में कहीं पे problem है ना?
James.
मेरा helpless है. मेरा helpless है.
Again, he said we receive. DP Goswami has sent it. It is submitted by Mr. Hussain that the present accused petitioner is innocent and he is no way connected in the arrest offense. He is a driver of the vehicle which was seized in connection with this case with the allegation of recovery of two cartons were from the contraband was recovered. As being a driver, he was supposed to pick up the co-accused persons, but when they were about to enter the vehicle with two cartons, the present petitioner refused to refused to take them, but and on that there was a altercation between the accused petitioner along with two accused persons. Police arrived at that time and all the three accused petitioners were arrested in connection with this case. He is behind the bars since last 165 days and got arrested on 24/10/2024. The court has submitted that though the grounds of arrest were mentioned in the forwarding report, there is no ground of arrest was mentioned in the arrest memo vis-a-vis the notice issued against him under section 47/48 BNSS. So considering this ground of non-compliance of the provision of article section 47 and 48 BNSS, which is a complete violation of the article 21/22(1) of the Constitution. The present petitioners are entitled to for bail. Next paragraph, Mr. Goswami, the narrative PP submitted in this report that there are sufficient implementing measures against the present accused petitioners, and recovery was also made from the conscious position of the present accused petitioner. Further, he submitted that the IO also prayed for extension of period of investigation, which has already been extended for 1 month for the investigation. However, Mr. Goswami admitted that the grounds of arrest were not being intimated to the present petitioner while issuing notice under section 47 of the 48 BNSS as well as in the arrest memo. Commercial quantity 37 follow probably. If the petition case is still under investigation, we are here. It will be under whose petition?
Malak.
If the case is pending before which court?
District Judge Golpara.
District Judge Gwalpara.
Malak.
Special Judge Gwalpara.
Specials as well.
Special just for. Okay.
Okay.
এইটো এটা কথা কৈছিলে এইটোৰ লগত এটা কিবা ৰেকৰ্ড আছে
Item 32, connected with production list, item 2.
You are also in 32.
Lordship,
You are also appearing on 32.
Lordship, both item Lordship. So in case of item number 32, Lordship, I'm behind the bar 350 days as on today, just because of 22, Korean cough syrup has been seized from co-accused Anwar Ali Sheikh, Lordship. That is in page 21 to 22 page numbers. Actually, as per the notification, so in page number 29, entry number 35. I have already submitted earlier. That's it.
Notification.
Notification, which is not falls under NDPS Act, which is falls under Drugs and Cosmetics Act. The entry 35, methyl morphine, commonly known as codeine, and ethyl morphine, and their salts, including dianine, all dilations and preparations, except those which are compounded with one or more other ingredients and containing not more than 100 milligrams of the drug per dosage unit, and with a concentration of not more than 2.5% in undivided preparations, and which have been established in therapeutic practice. And as per the level of the cough syrup, Lordship, it is 0.2%. Which will not come under the provisions of NDPS Act, Lordship, as per this notification. This is the exception, Lordship. Whereas, Lordship, the arrest is illegal, Lordship, as no grounds is provided to the petitioner, Lordship. LCR will shows, Lordship.
Have you marked the LCM?
Lordship, not only in page 34, Lordship. Thirty-four is the level of the cough syrup, Lordship.
No, we are not done that. Your arrest is illegal, you are saying that?
Lordship, most probably in the last page, maybe. I have not marked, Lordship, actually, in the LCR.
Have you marked? Have you seen?
No, I'll just check.
What is the stage of the case at present? Case is charge sheeted already?
Charge sheeted, Lordship. And one absconding is there, Lordship. And for that reason, charges are not framed till today.
One is still absconding?
Yes, Lordship.
Khairul Zaman. Your good name?
BLE still.
B. Ali
SK, that,
Sheikh. Heard Mr. B. Ali Sheikh did an counsel for the petition. And also heard Mr. B. Sharma did an addition appearing on behalf of the respondent. This is an application of section so and so, information is so and so. And copy of the case record has already been received. Where is the same? It is submitted by Mr. Sheikh that the present accused petitioner is innocent. And nothing has been seized from the person of the co-accused. Post he got arrested in connection with this case only on the basis of the statement made by the co-accused. And since 50 days he is behind the bar. Further, he submitted that the contraband which was alleged to have been seized from the person of the accused person, that is the cough syrup bottle, also does not fall under the proviso of NDPs. And as per notification and the wording, no, doesn't fall under the so and so. He further submitted that the level of the bottle shows that only 0.2% of Korean phosphate was available. And as per notification, it does not come under the provision of NDPS Act. Further, he submitted that till that the charge could not be framed by the prosecution as by the learned trial court, by learned special judge, as one of the accused is still absconding, which could not be apprehended till that. Mr. Sheikh further submitted these are the that no grounds were also mentioned in the arrest memo as well as in the notice issued under section 50A CRPC against the present petition. This is 50. 50 voter then. Vote in 50/50A CRPC. Mr. Sharma, the learned additional PP submitted in this regard that finding sufficient intimating materials against the present accused petitioner, the charge sheet was framed, charges was filed against him along with the other co-accused. However, it is a fact that the charges could not be framed till date due to as one of the co-accused is still absconding. However, the court took all the endeavors to procure the attendance of the co-accused, but till that the case is still at the stage of appearance. However, he submitted that case is of commercial quantity and rigor of section so and so. This is case is also from special just to be. Okay.
Bless you. And another is production article in the category.
Production.
In this case, Lordship, behind the bar is 359 days, Lordship. Otherwise, all are same.
Production item number. Rest is same, submission is same.
Same, Lordship.
His petitioner's name is
Hashim Pramani and Anwar Ali Sheikh.
And another is there.
Hashim Ali Pramanik and Anwar Ali Sheikh. We have to go by the photo.
No.
The grounds are not there. Both for Hashim Ali Pramanik and Anwar Ali. They're the same order. Okay.
Published Lordship.
Lordship, I beg indulgence, Lordship, regarding 37 case that is not there, Lordship. Anticipatory bail, Lordship, let it come after vacation, Lordship.
Which one? Item number?
37, Lordship. POCSO case.
POCSO. CD is not there.
No, Lordship.
And what is about the regards to this one notice? Can you tell us?
Notice.
37.
We'll take the instruction on that day. Lordship. We have not received any instruction.
After vacation.
CDB call for issue reminder. List when it can be listed.
Immediately after reopening, Lordship, let it be on 21st or 22nd.
21st, we are fixing somehow. 21st, 2nd, 3rd. All are.
6-5.
6-5 will do. 6-5 will do.
Hello.
How are you? What happened? Mr. Sheikh, your thing, Mr. P. Sharma is still not available.
Yeah.
Have you informed him, Mr. Sharma? In the morning hours, he was here, in fact. He was available here.
Must be on lakes on another court. Lordship.
Another court.
In the break, Lordship, I will get in touch with him, Lordship.
Just inform him.
Yes, yes.
Yes, your item number was? 26 and 33. Okay, we'll keep it.
Yeah, may I please, Lordship? It's item number 36. It is a CS file, so it may be closed, Lordship.
He has already filed. Are you on interim there?
No.
No.
They have their CS number was there probably.
CS number you have?
Case number 177/25, dated 16/3/25.
6-3.
16/3.
Or 16-3. Okay, we'll dispose of the matter.
Lordship.
There will be direction for regular bail. Connected.
Lordship.
Opposite party is not here yet. I'm appearing on behalf of the petitioner, election petitioner.
Now, there are two IAs are there, 156 and 158.
Yes,
IA
56 has been filed under Order 7, Rule 11 and Order 6, Rule 16 for striking. That we have already filed our reply on that IA.
So,
and
you are put in there.
Yes, yes, Your Lordship. Since this has been filed by the return candidate.
Okay, now you have filed your objection here, no?
Yes, Lordship. And today it was we are supposed to hear the matter today, Lordship, but the other party is not here. And then IA 58, in IA 58 also they have filed their reply. IA 58 we have filed.
IA 56, you are for the respondent, isn't it?
Yes.
IA
56, I am for the respondent, election petitioner.
Last time it was Mr. KP Pathak is engaged here, senior counsel.
Yes, he was there last time, and he's still there, Lordship. However, the other party is not here, so he could not turn up today.
The other one, Mr. Dabi was appearing on the last occasion.
Yes, Lordship.
So no one is there from the petitioner side?
I have just called him up. He said he's on his way, Lordship.
No, we cannot wait, no? We have some other matters also.
Lordship, so Lordship, in that case, can it be fixed for hearing on 24th, Lordship?
24th of April?
Yes, Lordship, because in between there is puja break.
Someone has come.
Oh.
Okay. Mr. Dabi, you were...
Yes, I received the affidavit filed by the election petitioner in Miss case 58.
Yes.
56.
No, in 56. They have already filed their objection, I think.
Yes, I have received.
You have received?
Yes.
So then, are you ready for the hearing on the matter?
For hearing next, that may be fixed. A date may be fixed for hearing.
So you are not prepared today?
No, not today.
Mr. K. David, the learning counsel for the applicant, also for Mr. A Tata, the learning counsel for the respondent number 1. Mr. David is learned counsel for the petition submitted that they have already received a copy of the written statement filed by the other side. However, he sought for some time for the hearing. When your Mr. Tatak is saying that on 24th April will be convenient for him, will it be convenient for you also, Mr. David?
April is
24th of April?
yes.
Since
Mr. Pathak, the senior counsel, he will be also available on that day.
Lordship, I'll have to check it out, Lordship. I have not asked for the date, but however, since we have time till 24, so I'll try to inform the same to sir, and then inform him the date.
It on 24th.
24, Lordship.
4th of April.
For hearing of I-56 as well as 58, Lordship.
Yes, 56 will be heard and 58. Yes, what about the 58? Here you are the petitioner.
Yes,
Yes.
I am prisoner.
No.
58, I'm the applicant, Lordship.
Yes.
Since this is pertaining to documents, Lordship, some of the documents we could not get hold of certain documents. However, those documents are with the returning officer. So during the time of documentation, if that documents may be called for, then so that we can exhibit the documents, since it is a public document.
Returning officer?
Lordship?
Returning officer, who is representing the returning officer?
Returning officer, I think in this...
A. Anju.
Yeah.
Its returning officer is a pro forma respondent number 2 here.
Yes, Lordship. So I think no one is appearing on behalf of returning officer in this matter.
Whether notice was issued in that regard?
Yes, Lordship. Steps were also taken, Lordship.
In some of the matters, Ms. Anju was appearing.
Yes,
the
Lordship.
returning officer in some of the other matters, connected matters, not
Yes. Yes.
But here I don't know whether she is appearing or not.
Yes. Lordship, in this matter, returning nobody is representing returning officer.
I think they have not sent notice.
No.
Notice was not sent, in fact.
Lordship, notice has been sent. That must be that we have filed in the form of affidavit also, Lordship. It must be in the record. I don't have the record with me as of now.
We have filed in the main case. Notice was issued to the returning officer, and
Yes.
most probably there Ms. Anju was also appearing.
Yes.
Do one thing, you can just verbally also intimate her because she is appearing otherwise.
Yes.
In the main election matter, because the returning officer has a preferred respondent. But however, as you have submitted, the documents are in custody of the returning officer. So,
Yes, Lordship.
her presence is required, in fact. To pass
Yes, that is with regards to I-58, Lordship.
Yes,
So
yes,
I'll inform the same.
the next day, if she agrees, the documents which are lying with the returning officer, then the matter will be easier for us. So let
Lordship.
her appear on the next day. before us.
Lordship,
Otherwise, we are fixing it on same day on 24th of April.
Lordship.
Address.
And before that,
Here, Mr. Dabi, you have appeared and have you filed your written objection here?
Yes, I have filed. No,
You
no,
have
this miss case is not for calling of records. They need this is different.
58 is for what?
no. Lordship, here in 58, Lordship, as I have stated earlier, as I have submitted earlier, this some of the documents which is with the returning officer only for that. In fact, we have sought leave of this court to either to produce the during the course of hearing or during the during the documentation. Only that much. So we'll fix, Lordship may please to fix it on.
If the documents are in custody of suppose returning officer, there
Yes.
has been an order that he may produce this one at the time of hearing, or
Lordship.
through you it can be produced.
Lordship.
I am saying that her presence is required. That's what I. And
Yes,
Mr.
Lordship.
Dabi, in this case, have you filed any written objection? Is it required?
They have the return candidate has filed their reply.
Already filed.
Yes, they have already filed. So we, Lordship, may I suggest that this may be fixed on the same day? I mean, we'll take up the hearing for IA 56 pers, which has been filed for under Order 7 Rule 11.
Yes.
That will be, that may be taken up first, and thereafter IA 58 may be heard, Lordship.
Obviously, then only it will come.
Lordship, yes.
First, we have to dispose of the 56 because
Yes,
it's
Lordship.
Order 7 Rule 11. So otherwise, then we'll fix it out. Okay,
Lordship.
then what will be matters of fixed at on 24th of April? 24th of April. Okay. This 58 will also be fixed at 24th of April. Vis-a-vis the main case is also be fixed at 24th of April, the election petition. All the three matters. Okay, Mr. Dabi?
Yes, 24th.
Yes, 24th of April.
Yes.
Lordship.
Lovely.
Deeply obliged.
Oh. And so, CDB written till next date of listing. Okay, obliged.
Timing 17.
9 one is done and whatever. Oh no, one is 33 and another. Is it a whole issue setting? Which item we are on?
17.
17. Mr. Borman is not here now. Huh? In item number 17. Yes,
Yes.
Again for timing because they were there morning hours for timing only.
How do you first?
23.
23 was also timing.
Yes.
My lord, affidavit is on record now.
It has already come.
In this case, my lord, if I say I'm totally innocent person, even nothing against me. My first round, my lord, the arrest procedure. Ground is not mentioned. And second round, my lord, I am protected by the Tufan Singh. My lord, kindly see page 11 in the FIR. Nowhere my name is mentioned in the FIR. Nobody whispered against me, my lord, nothing. And my lord, kindly see the subsequently I was arrested. Suddenly, my lord, page 18 is the forwarding report. May I read, my lord? The forwarding report. In FIR, nothing against me, my lord. My name is not mentioned. I was not made an accused in the FIR. And if in forwarding report, my lord, page 19, ground of arrest. The arrested accused person Injamul Haq Babu is, that is me, is working as a travel agent, is found involved into the case for illegally dealing the narcotic drugs suspected to be ganja at the shop of Tafadar at Batoya, and is close associate to the accused Abul Hassan Tafadar, the owner of the hardware shop building at Batoya, who is currently evading from the arrest of police to this case. I don't know these two persons. And how I am connected with these two persons, this is also not mentioned. Second, one of the recovered and seized drugs is suspected to be ganja of total 800 kgs were found in the shop of Abul Hassan Tapadar at Patoya. I am not Abul Hassan Tapadar, man. Which was brought from the founded shop of Abul Hassan Tapadar, which was brought to Tripura state. Bilal and Russell Ahmed was supposed to be delivered to the arrested accused person in Jamul. Supposed to be delivered. In fact, my lord, I am a Aadhaar card. My lord, I am doing something work in Aadhaar card as per given by the authorized by the government. My lord. Now, para number 3, as per the CDA details record analysis found that there was a linkage of call contract communication between the supplier Bilal and Tripura of Russell Ahmed with the this is CDR, my lord, with Russell Ahmed of Samada. They were also not arrested. So these are the ground, my lord. In fact, my lord, I am doing the other works for which I have contact with some many persons, my lord. So my lord, I am working in a political party, and there is a apprehension that I will going to contest election, panchayat election upcoming. So I was picked up, my lord, in a conspiracy. So my ground is this. The grounds of arrest is I have, my lord, filed an additional affidavit in this regard, and I would like to place some judgment.
Grounds of arrest are not there, then we need not go into all these things.
These are the minor rulings. No ground is mentioned.
We have filed one additional affidavit wherein it is seen that the grounds of arrest was admittedly not mentioned. Otherwise, since when he is in custody?
I have been in custody, my lord, since 2010, 2024.
2010,
2024.
It is not a charge sheeted case, na? It is
charge sheeted case.
already
Yes,
seen.
Cognizance has been taken.
Okay. The charge is not yet framed.
Because of one co-accused is absconding.
One co-accused is still absconding.
Yes.
On the face of the record, I am innocent, my lord. In fact, I am innocent today. I was picked up.
Hard Mr. 23, hard Mr. H.R. Chaudhary, the learned counsel for the petitioner. And also hard Mr. B. Sharma, the learned additional PP, appearing on behalf of state respondent. This is an application of the section so and so in connection with so and so. City received, Paris decision, hard website. The petitioner has also filed one additional affidavit to bring some record on, to bring some documents on record. And so it is next by, it is submitted by Mr. Chaudhary, the learned counsel for the petition, that he is innocent and no way connected in the alleged offense. From the grounds of arrest also, it is seen that there is no materials to book him in the connection with this case. However, he was arrested on 24/10/2023, and since then he is behind the bar. Post-op case has already been charge sheeted. But the charge could not be framed due to absence of one of the co-accused who was shown as an absconder. Baki submits he was next para, he was arrested merely on the basis of a statement made by one co-accused. However, it is settled position of law that the person cannot be, the person cannot be convicted or, and it is not admissible at the time of trial. No. To financing to provide is relying on to financing also. Further, 2 grounds, 47 BNSS, arrest memo. The grounds of arrest were not mentioned. The document inspection memo, arrest memo, and the notice under 47 BNSS. Grounds of arrest were not mentioned. Illegal, no recovery was made. He is innocent. Mr. Sharma submission of Diva had Mr. Sharma, the learned counsel for the petition submitted in this report that case has already been charged finding for asymmetries against the present petitioner. However, the charge could not be framed due to absence of one of the co-accused who was shown as an absconder. To whose satisfaction this one? To whose satisfaction?
Sir, this one, my lord, Session Judge Karimganj, Session Judge Sribhumi.
Special Judge Sribhumi.
Additional Session Judge Sribhumi.
Additional, not like a special Judge Sribhumi. First page की बात आसे just wrap it. First page आसे की बात. Do you want the short name definition? Wrap it. Wrap it. Okay.
Oblige.
CD has not been received.
He's given detention for 40 days, madam. Case of 140 subsection.
Case of
140 subsection 3, madam. Case of elopement, madam.
Elopement.
15 is recovered, madam.
Already recovered?
Yes, madam.
Since when he is in custody?
Madam, 27/2/2025.
His POCSO is added also subsequently?
No, POCSO not there. To my knowledge, madam, in her 164 statement, she has not uttered any such thing, madam.
Also, we can call for a status report by Friday, Lordship. Regarding a further custody interrogation is needed, or even the 164, Lordship, 183 statement can be.
These are not available.
No, CD is not received, Lordship.
From where you're saying that she has already been recovered? Oh, from the statement forwarding.
No, but the relatives, my lord, from relatives of the informant, my lord, they informed that she did not said anything about her, my lord, because actually both the parties initially they agreed to the marriage, but due to some pressure, my lord, they later backed off, my lord.
The forwarding, Lordship, she is stated to be a minor, so subsequently POCSO may have been added, Lordship.
That's right. As per his instruction, there may not be anything, I don't know.
Yes.
But we don't have anything to see actually whether she has already been recovered.
She recovered from the forwarding
report. No,
Forwarding
that,
report
on that day, most probably you submitted in that manner also. Is there any intimation from the IO why
No,
CD
Lordship,
could not
nothing.
be? No intimation.
A date may be fixed also, we produce the case that your status report, Lordship.
We don't have any dates before Bihu. It has to be after Bihu only.
The Bihu, Lordship, 140 is 90 days. 140.
140 is 60 days, madam. 143 it is 60 days.
Now your petitioner is?
He is 40 days, madam. Because the punishment is, madam, 7 years.
And that is the present, at present, this is the case.
Yes, ma'am.
But
if,
as Sharma is saying
yes,
that
ma'am.
she is a minor, So I don't know if there is any relationship was there or not, if section 6
Yes,
or
yes.
4 is added, that
Yes.
is the questionable
Yes,
only.
yes.
So today is your 40 days now.
Telephonic instructions, they may obtain my lord instruction.
No, we don't have it dates. Telephone instruction, what do you want to obstruct?
Well, whether they have added any section, police have added any section regarding POCSO, my lord.
Acha, that instruction.
Because in the lower court today, my lord, we did not find anything like that, my lord. Today also we searched whether any search sheet was submitted. So I sent my junior, but nothing is there, my lord. No section is added till date, to my knowledge.
As
my
per
lord.
your instruction.
Yes, my lord.
Ms. Sharma, what to do?
I would have prayed for a late lordship, but since lordship's calendar is full, lordship, then it becomes difficult because 60 days will be over. So, either lordship I
60
can
days
try.
will not be over, by the way, but
Also, we can try to communicate with the IO right now, lordship will try.
okay. Suppose if, as he is submitting that if subsections are not added till then there may be a ground. That's right. Okay, you will take instruction. Okay. This time. New call twice. Production is good.
Production list item 1, connected with item 46.
Made to the law. But first, I would like to pray for withdrawing the item number 46. Because in the statement, in the
Yes, on the
petition.
day you have submitted, yes.
Yes, we are given the statement below.
I was informed there is some, miscommunication with the private secretaries on that regard. Actually, I can remember I was telling that you may withdraw this one because
Yes.
there are some technical
Yes, yes.
irregularity by that time, but Mr. Burua was there, I think, on that day. He suggested that at least one order should be there so that we can call for a case diary.
Yes.
It may be. But that was not uploaded, I think, there due to some miscommunication, I think. So CD may not be available today.
Yes.
I think so. Otherwise, you have already filed one BA.
Huh.
Yes. Since in that connection, in BA, you are in custody since when now?
3-4.
3-4. Since 3-4.
Otherwise, my lord, I am in custody from 15-3. My lord, the ground which I'll ask my lord, I don't think CD would be required. CD would be required for other purposes. Now, if a lordship would kindly permit me, I'll just take 5 minutes time. My lord, in the other case, in that North Lakhimpur PS case, lordship was pleased to grant ad interim bail on 27/3/25 without calling for the CD. That was also a case under my lord when he was in custody. Now, my lord, on 28/3/25, the present FIR was lodged in respect of an occurrence of 10/8/2024. Now, if a lordship should kindly come to that FIR for a moment at page number 62. Page 62, with reference to the subject cited herein above and the credentials, I, the undersigned, hereby lodge a formal complaint against Ritam Singh, Twitter handle @Singh Ritam, for publishing, circulating statements of public social media platform, which is deeply derogatory
having potential to provoke caste-based enmity, disturb public peace, and incite violence, and thereby promoting disharmony and feeling of hatred or ill will among different religious groups or castes or communities, especially the Brahmin community, in the following manner. Now, kindly see the informant, my lord, she is aware that my Twitter handle is @ Singh Ritam. She writes in the first para. Now please come to the second para. In a tweet dated 10/8/24 at 9:19 p.m., accused Ritam Singh through his verified Twitter handle, named Vengeance, was urging Dalit to peace in the mouth of Bamun workers and further urging that society needs badla from these Nazi mophos. So, my lord, by the affair itself, she says that the offending so-called news item or article or the tweet was published on 10/8/24 in Vengeance. Vengeance is not my Twitter handle. Now, my lord, the other day I had handed over a copy. Kindly see, my lord, somebody must have done photoshopping. Vengeance. The day the Dalit starts pissing in the mouth of Bamun workers, making them clean sheet and sweep roads, that would be the true social justice for Ambedkar. Now, this is not my Twitter handle. So, was it not necessary? Now, my lord, please come to the FIR once again. Kindly see the enclosure part, my lord. Page 63. Enclosure screenshots of all tweets. Now, what was taken note of was screenshots of all the tweets. So it is in Vengeance, not in Singh @Singh Ritam, which according to her is my Twitter handle. Now, in view of this discrepancy, was it not necessary on the part of the Milord informant or the police to verify actually what is the actual state of affair? Is it so necessary to register this case, Milord, that I was enlarged on bail on 27 and this was done on 28 because the application was filed and the copy was served to the government? Now, Milord, and it was of August. And why she was waiting till, Milord, 28th of March? Now, Milord, kindly come to page 64. Just see, Milord, how things have been done, whether this can be permitted. Page 64. Seen the prayer made by OC Morigaon PS, praying for issuing production warrant against the accused Ritam Singh, who has already been arrested in connection with North Lakhimpur PS case number so and so, and is presently in judicial custody of North Lakhimpur District Jail. IO has stated that the accused person through his social media handle has been making derogatory and hateful comment against different caste and community, especially the Brahmin community, which has the potential of inciting hatred by instigating one community against the other. Accordingly, the IO has prayed for issuing production warrant to produce the accused in connection with this case for the purpose of taking further necessary legal action. Hard Lanet APP produced the case record. Considering the supportive documents submitted by OC Morigaon and the contention of the FIR, the prayer of OC Morigaon is allowed. Issue production warrant directing the Superintendent Lakhimpur, the Central District Jail, to produce the accused to the court in the court of the Chief Judicial Magistrate Morigaon immediately. Now, my lord, kindly see, date fixed was 5/4/25. Normally, my lord, these are all produced on the day when it is fixed, normally. Now, my lord, because of this order, now this petition was moved before the special judge not Lakhimpur. On same date, my lord, 29/3/25. Page 66. The accused Ritam Singh is connected with court through VC and is represented by the engaged counsel so and so. State is represented by learned additional PP. Seen the prayer of the superintendent of district jail Lakhimpur to allow to physically produce the accused Ritam Singh before the court of the learned additional CJM Kamrup on 2/4/25, not Mohaldoy court. Peruse the record, also seen the copy of the production warrant issued against accused Ritam Singh by learned CJM Kamrup, Guwahati on 2/4 so and so, which is annexed along with the prayer of the superintendent of district jail Lakhimpur. Production warrant was issued by learned additional CJM Kamrup Guwahati against accused Ritam Singh for his production before the court of the additional CJM Kamrup Guwahati on 2/4/25. Accordingly, prayer of the superintendent of district jail Lakhimpur to produce accused Ritam Singh before court of learned additional CJM dated Guwahati on 2/4/25 is allowed. Further, superintendent of jail Lakhimpur is directed to make necessary arrangement for physically producing the accused Ritam Singh before this court on 10/4/25. Send a copy of this order to the learned CJM Guwahati so and so, OC, not Lakhimpur PS. Accused Ritam Singh is remanded to judicial custody 10/4. So, my lord, as per the order of the special judge Lakhimpur, he should have been produced before the CJM Kamrup, additional CJM. But he was produced before Mohaldoy. So what is going on, my lord? Morigaon. So something is fishy somewhere. In every locality, we every day hear cases of theft. There they cannot catch hold of anybody. There are snatching of chains. Everything is going on. The big ones are plundering. There, my lord, no law and order is required. Here, when it comes to political opponents, then they will go to any extent. I think, my lord, lordship will not permit this. End of the day, it is the liberty of the citizen which is most important. Because in this way, my liberty under Article 21 and 22 cannot be permitted to be, my lord, flouted. It's a clear-cut case, my lord, where arbitrary exercise of power has been crept in. I'm very sorry to say, my lord, that special judge Lakhimpur has played passed such an order. We do not know, maybe the special judge Lakhimpur is correct also. We do not know what record was produced. I don't think that learned special judge will make such mistake, my lord. Maybe they have produced a production warrant from additional CJM Kamrup Guwahati. We do not know. So the production, my lord, the lordships will enlarge him on bail, that is a different aspect. But I think, my lord, this matter should be taken to its logical end. If necessary, an inquiry on by the administrative side by the High Court is also called for in this case, my lord. And it's a very serious matter. So, my lord, question is, number one, the Twitter handle is @Singh Ritam. The offending article or the tweet is in vengeance, which does not belong to me. It is very easy to Photoshop, my lord. The alleged occurrence is of 10/8/2024. If she is so, my lord, assertive, if she is so conscious of her right, then she should have come immediately. Why was she waiting for 28? Because on 27, the petitioner was enlarged on bail. Taking everything into consideration, my lord, I will respectfully submit, my lord. This is abuse of power. So lordships will not permit this and enlarge him to go on bail. And for the other purposes, my lord, lordship will keep this proceeding open and take necessary action. That is my humble suggestion.
In my respectful submission, lordship, the arguments that has been advanced, those are fit for a passing proceeding, lordship. This is a bail application before a lordship. Allegations are there before the in the FIR also, lordship is seen. He's a habitual offender, lordship. Number of times he has been making such comments, lordship, derogatory as well as inciting the communal violence, Lordship. In page 63 also, Lordship will kindly see paragraph number 3 and 4. 63, Lordship.
Yes.
The accused person, Vitam Singh, is a habitual offender in the state, history of repeatedly committing similar religious and caste-based inflammatory offences in the state of Assam, which is otherwise historically devoid of any class or class difference, wherein persons irrespective of any caste, religion, race, caste or community live in a harmonious relationship. Number 4, it is worth mentioning that previously he was arrested in Panbazar PS case number so-and-so under section so-and-so, read with section 66 of the IT Act 2000, as well as Dispur police station case under section so-and-so, Lordship. This clearly indicates a consistent pattern of criminal conduct. It also relevant to note that so-and-so, Lordship. So this is not the first time, Lordship, that he is involved in such type of offences. And moreover, Lordship, the credential of the informant, Lordship, that cannot be dealt with by your Lordship, because this is not a passing petition, Lordship. This is an FIR. Lordship will kindly go by the case diary and the materials contained therein. And also, Lordship, whether the comments has been made by the accused or not, Lordship, that will be revealed only from the investigation conducted so far, Lordship, whether it is his Twitter handle or not, Lordship. So at this stage, Lordship, I am praying for calling of the case diary. Lordship will kindly table the same. And if there are no materials, Lordship, he may be under bail. That is my respectful submission, Lordship.
My lord, my two-line reply would be, my lord, these arguments that, my lord, this is not a quashing petition, this is a bail petition, these are not arguments which has to be entertained in High Court, my lord. End of the day, my lord, High Court is a court of record. Under Article 215, High Court is a court of record. So my learned friends should know what is the meaning of court of record. If in a proceeding something wrong emerges, then that's a very serious thing. There is nothing like in a bail petition court cannot take, which judgment says, which Honorable Supreme Court has said, my lord, that in a bail petition, if aberrations is prima facie violation of fundamental rights and notice, actions cannot be taken. End of the day, Lordships exercise the power also under Article 215. Therefore, my lord, these are not arguments not to be anyway, my lord. I am not saying my learned friend cannot make the argument, but these arguments are without any substance. So it is your lordship's discretion, my lord, in a matter of bail. So I'll respectfully submit. Lordship will exercise the discretion which should be in favor of liberty of citizens, my lord. That's my only submission. Deeply. Okay. Deeply.
Sign. Another one, G2 আছে, আপনার 46 G2 আছে না? 46, that will be disposed of. Submission টা লিখো, আর Mr. Ken Chaudhary, the learned senior advocate, assisted by, who was assisted? H. Buragohai. And it is submitted that due to there are some technical irregularities for which they was to withdraw the same. Prayer allowed, disposed of on withdrawal. So, there is a 46. Huh? Item number 40. Item number was 46. Huh? No, AB item number 46 is
Supplementary list.
46. This is disposed. 46 is disposed.
Regarding this, Lordship will pass order later on.
I'll pass the order. It's not passed.
35.
34 to give.
35, Lordship, charge sheet has been laid.
35.
Yes.
You are appearing for the response number 2. Are you on interim there?
Yes, Lordship.
Earlier you were on interim?
Yes, Lordship.
This is of POCSO.
Yes.
6 POCSO.
Yes. Charge sheet number.
Yeah. The CS number?
Case number 21/25 dated 31st of January 25, 310125.
What you are, Mr. J.R.
GR Singha.
J.R. Sinha. His name is here. Heard Mr. J.R. Sinha, the learned counsel for the petition. And also heard Mr. B. Sharma, the learned additional PP appearing on behalf of state respondent. And Mr.
R. Ghosh.
R. Ghosh.
On behalf of NG Kundu for respondent.
R. Ghosh appearing on behalf of Mr. N.G. Kundu for the respondent number 2. This was fit for case diary, but it is submitted by Mr. Sharma. That case has already been charged by its CS number 21/2025, dated 31/01/2025. It is submitted by Mr. Next file. It's submitted by Mr. Singha that the petitioner was on interim bail, dated 13/2/2025, and accordingly he paid for extension of the same. Next file. Considering the submission made by learning counsel for both sides, and also considering the fact that the case has already been charged, the present petitioner, the present petitioner is hereby asked to appear before the learned trial court below with an appropriate application for bail, which may be considered in accordance with law. However, till 15 days from the date of order, that however, his interim order of interim prior bail dated 13/2/2025 is hereby extended till 15 days, enabling the petitioner to appear before the learned trial court below with an appropriate application for it.
May please your lordship, the interim bail will be
Extended for
absolute?
15 days.
Will be made absolute, lordship?
No, it will be extended for 15 days. Case has already been charged to appear before. So we have made observation. We will make it.
Lordship.
38. May please your lordship.
Are you on interim day?
No.
It will likhi diba. CS number, yes.
25,
1/25.
dated 31/01/25.
31/01/20. Here interim order with a direction to appear before the learned trial court below. Abhi low level sub number one. So it's okay. CS number to likhi diba 1/2025, 31/01/2025. You appear before the learned trial.
Lordship, also item number 34. Item number 34, Lordship. I made a telephonic call, Lordship, and it has been informed to me that it has already been charged.
Oh, it has already been charged.
But not under any POCSO Act, my lord.
Whatever. But charge sheet has been laid, Lordship.
Not under POCSO, you are saying. Under which section? Can you tell me?
We do not have that information.
Number and dated is there.
Let him appear before the court and before a bail application, Lordship, because already charge sheet has been submitted. Charge sheet number 68.
CS number?
68/25.
68/25.
Dated 28/02/25.
28/02/2025. Okay, you can appear. Same order hoga. He is directed to appear so and so.
He's in jail. We'll file a bail.
To file an appropriate bail application before the learned court below. That may be considered.
$39.
Yes.
In this matter, there was call for. FIR is registered under two sections, lordship. One is bailable and other is non-bailable, lordship. 309 is non-bailable and 351 is bailable, lordship. Criminal intimidation. And
309, what says? It's 309.
robbery. Lordship, what happened, lordship, kindly have a look at the page 11 is the FIR, lordship. Allegation is that the petition number 5 called the informant on 21/2/2025. Then on 23rd, other petitioner forcefully brought him to Guwahati, lordship, for some negotiation with the petition number 5, lordship. Lordship, have a kindly look, have a page, have a look at page 13, Lordship, kindly. The names of the accused persons, Lordship. He has mentioned serial 4 and 5 are same, Lordship. Mobile number, father name, son, and everything. Only name Gitu Tiwari, Jitu Tiwari.
1 and
4 and 5, Lordship. 4 and 5. Page 13, Lordship. Is the third one.
they are brothers.
Not brother, same person, but mentioned twice, Lordship. Mentioned twice, Lordship.
No, from where you are seeing, they are not same brothers.
But he has no brother. Petitioner is actually the Jitu Tiwari. He has no brother in the name of Gitu Tiwari, Lordship. And mobile number is also mentioned same, Lordship.
Your petitioner is Jitu Tiwari.
Jitu
Biswajit.
Tiwari. 5 petitioners are there.
Achha,
Lordship.
5 petitioners.
5 petitioners are there. Actually, Honorable Lordship, the informant is the chairman of SC Development Board, Subdivisional Board of Huzai District, Lordship. He is alleged to have been involved in some appropriation of money, Lordship.
He is the board of what?
From an
Interim?
SC Development Board, Lordship.
Director,
Vice Chairman
Vice Chairman.
of Huzai District, Lordship. And there is some news circulation about his financial embezzlement, Lordship. And he was apprehension that there will be some news circulated in news channels, wherein the petition number 5 is an anchor, Lordship. Petition number 5 is an anchor in that very news channel, Lordship. On that apprehension, Lordship, he concocted this entire story and make this file this FIR at Dispur, Lordship. Though the alleged incident occurred mainly in Huzai, Lordship. And on that day, Lordship, the petitioners are not, other petitioners are not available at Guwahati. So far allegation of the informant is concerned, Lordship.
So a video was viral, Lordship, with some currency note from the informant husband, which they are working in that job, Lordship. And these petitioners are associated with some news channel, and one is the anchor of a news channel, 5. The number is number 5 is the anchor of a news channel. And they first called to the informant husband regarding some negotiation of not to viral, not to telecast the video any news channel, Lordship. And he was that on one morning, Lordship, went to his house and they took him to Guwahati. When the informant husband called the informant that I am in trouble, and they were detaining me at Guwahati. So the informant and some persons came to Guwahati, and they were found this victim in a vehicle with door locked, and then the petitioners are inside the vehicle. When at first when they tried to open the door of the vehicle, they were not open. Later on, they opened the door and they went away from the place of occurrence. These petitioners are at the place of occurrence in the vehicle, at the vehicle, and thereafter the victim said that they demanded 10 lakhs rupees from that negotiation process. Some witnesses are there, they have said it's the same thing. They demanded and threatened that they will publish the video in some news channel if money was not paid to them.
Some news channel are blackmailing some person.
Regarding blackmailing, they will viral the news on all the publish the news video on the news channels if he will not pay the money to them. They demanded 10 lakhs rupees as far as the statement of the witness who are along with the informant from the Huzai to Guwahati. He was detained in a vehicle at the place of Beltola. He has recovered them. They went away from the place of occurrence after their arrival.
Petitioners will cooperate, Lordship, with any stringent
Materials are there.
with any
They are
stringent
doing illegal things and threatening the person and demanding money is not good for the society. So at this stage of investigation, they were not allowed to anticipate at this stage, Lordship.
they will cooperate, Lordship, with any condition, Lordship. And nothing was recovered, nothing like that, Lordship. So the informant came with money or given something, Lordship. Merely allegation is there that demand that.
The only
lawsuit.
thing is
With
that my
any-
humble submission that being a part of the fourth, they are setting the fourth pillar of democracy. This is not
Only petition number
acceptable and regardless.
five, but others are not the lordship media persons. And with any stringent condition lordship, they will appear lordship within once in a week lordship. And cooperate in the investigation lordship. Others,
So Mr. MK,
MQ Hussain lordship.
heard Mr. MK Hussain, the learned counsel for the petitioner, and also heard Mr. DP Goswami, the learned additional PP, appearing on behalf of state respondent. This is an application in the section 12, connection with suicide. Case diary received, jurisdiction. It is submitted by Mr. Hussain that the present accused, all the present accused petitioners are innocent and they are not connected with any offense as alleged in the FIR. The petitioner number, your petitioner number is now 5.
All are lordship.
No. Who is working in a new channel?
5 lordship. 5 is working.
Khaliduzzaman.
Khaliduzzaman Chaudhary, yes, lordship.
Petitioner number 5 is also working in a news channel as an anchoring some news channel as an anchor, and the other petitioners are not not associated with any news channel. Further, he submitted that the present case has been lost only under some grudge against the present petitioner, as some news was made viral in some news channels regarding some financial embezzlement of the husband of the informant.
Informant lordship.
Informant himself. Of the informant, who is working as a chairman of SC Development Board. Oh, sorry, vice chairman of SC Development Board. Further submitted that all the petitioners are the local person and they will cooperate the IO in further investigation of this case if they are granted with the privilege of pre-arrest bail. Next para. Mr. Goswami, the learned additional PP submitted in this regard that it is a fact that there was some allegation of embezzlement of financial fund by the informant, and the present petitioners were invited by the wife of the informant only to settle the issues so that the news channel so that the news of her husband is not made viral by is not being filed by the news channels. But today, in that regard, when they came to before the petitioners, they took him to Guwahati and keep him inside the car. When inside the car, and on the information when the wife along with some persons visited to the place of occurrence, he subsequently fled away and also demanded ₹10 lakhs from the informant, threatening that they will make viral all the videos of the present informant. Mr. Goswami accordingly raised objection and submitted that being a media person, they are not supposed to involve themselves in such offense, who are considered to be a fourth pillar of sedition. Accordingly, he submitted that custodial interrogation may be required for the proper investigation. Next para, hearing the interest submission made by learned counsel for both sides. I find it justified. I find it proper to extend the privilege of interim pre-arrest bail to all the petitioners. I'm granting you interim only, all the petitioners, so that they can appear before the IO and can cooperate in the investigation of this case. Against condition DD1, CDB returned, calling for an updated case diary, list accordingly on 9/5. We are listing it on 9/5, cooperate with the IO.
Timing 8.
Well, I have confirmed, got the confirmation that no 47-48 notice was served. And as a proof of this, when the charge sheet has been filed, here categorically mentioned the documents has been filed, but there is no mention of notice under 47-48.
So in the morning hours, I was asking you to collect, if any, certificate
Yes.
copy. You have collected?
No, they said that nothing has been served to upon. But the charge sheet that has been submitted here, I have copied the copy. Here categorically mention all the document, list of the documents, except notice, any notice 47-48. It is not mentioned here. That indicates that it was not done. Anyway, if you lost it for your satisfaction, call for the report matter or this copy, record, whatever is.
Record may be called for, after present record also will decide.
No, but we don't have any date before Bihu.
After Bihu also.
Yes, so there is no other way alternative.
That's why I fixed it at 3 PM so that you can procure something.
No, I had a talk with the concerned advocate who has forwarded this case to me. He said that you verify the charge sheet. There was no mention of these two columns.
After Bihu also.
Copy of the charge sheet you have filed here.
Yes, charge sheet is here.
What is this?
Charge sheet.
You're holding charge sheet.
Original certificate.
Have you annexed the forwarding also here?
Forwarding is there.
Yeah, obviously in the list of documents, the 47-48 or AS memo is not there.
It is not there.
But it is thing is a bit different because at the time of forwarding or the report, they generally.
No matter, it is a forwarding, it is also not here. I have given page 22. It is not mentioned.
Page 22.
The reason for arrest has been given.
Then we are not in a position to say anything because the notice, I mean the enclosures column is not there. So now that is why we are saying. Because what is happening, just for communication, I'm just telling you. that generally in the forwarding report, when the accused is forwarded,
It remains.
these are the accompanying document.
It is not here.
So, but the charge sheet, because these are not accompanying document, because during the investigation, which have been recovered or which were be collected by the other, those were there. So that may be one of the reason why it's not been mentioned. So we have to call for the question. Today it was in motion stage, I said, motion call.
Today motion, madam.
That's why in the morning hours, I just asked you if
Exactly.
you can collect this one.
We
but
thought
it's
that
not
I
here.
could get a bail my lord due before due. Anyway.
After we have immediately go. 24th of CD call query. It's a charge sheeted case. Charge sheeted one.
Trial
Oh.
court records.
Okay, scan copy.
17.
Yes.
Worship here, NDPS matter, my lord. I am behind the bar for last 2 years, 3 months and 3 days, my lord.
2 years?
3 months and 3 days. Out of which, my lord, 20 days I was granted interim bail, my lord. My mother died, my lord. And accordingly, after 20 days, I have surrendered and I was taken into custody, my lord. So my prime contention is that, my lord, Article 22(2), my lord, which says, my lord, may I read, my lord? Says that, my lord, I should be produced before within 24 hours before the nearest magistrate. May I read? Every person who is arrested and detained in custody shall be produced before the nearest magistrate within a period of 24 hours of such arrest, excluding the time necessary for the journey from the place of arrest to the court of the magistrate, and no such person shall be detained in custody beyond the said period without the authority of a magistrate. And only on 2 conditions a person can be kept in custody beyond 24 hours. That is when it is enemy alien and under preventive detention, my lord, which is I am not. And section 57 of CRPC also says that, my lord, I should be produced before a person should be produced before the magistrate within 24 hours of his arrest. So, which has not been done by the NCB in my case. So, in support of my contention, kindly come to page number 14, my lord. A secret information was received by the authority, NCB authority, my lord. Page 14, my lord. Page 14, my lord. It is the information reduced into writing, my lord. It has been done on 1/1/2023 at 1545 hours, my lord. Just below that, my lord, the superintendent has directed and authorized that, my lord. May I read, my lord? The handwritten, my lord, bottom. A team may be constituted and proceeded toward Madanpur Toll Plaza, Kamrup Rural, to intercept the aforesaid truck bearing number so and so and apprehend the suspect person as per provision of NDPS Act and other relevant laws. So it has been authorized that as soon as this person, and specifying my name, my lord, in this document, my lord, I have been the authority has been directed that the suspect, that is me, should be apprehended as per the provision of NDPS Act. Therefore, thereafter, my lord, on at Madanpur Toll Plaza, my lord, at Sangsari, my lord, the team went there and intercepted the truck, my lord, on 2/1/23, my lord, at 2 a.m. Thereafter, due to some reason, the truck and me was taken by the authority to the office of the NCB at 6 Mile, 6 Mile Guwahati, my lord, on the same day. Thereafter, search was conducted, my lord. Kindly come to page number 60. So, under the custody of the respondent, my lord, I was taken from Madanpur Toll Plaza, Sangsari, to
6 mile NCB office, Guwahati, my lord. Kindly come to page number 16 now, my lord. That is the seizure list, my lord, whereby the LS contraband were seized, my lord.
16.
16. The seizure list.
Yes.
My lord, number one box says 6,483 bottles of Procedural cough syrup has been seized, my lord. The contraband. Now kindly come to page number 17, my lord. Just below the box, my lord. Search started at 1,000 hours on 2/1/23 and completed at 1,800 hours on 2/1/23. So, my lord, search was completed and recovery was there, my lord, on 2/1/23. So, at that moment, my lord, at least at that moment, I am presumed to be arrested, my lord. But it was not done, my lord. Thereafter, my lord, I was produced before the. Can we come to page number 18? On 4/1/2023, my lord, I was produced before the special judge Kamrup Aminga, my lord, not before the nearest magistrate.
You were produced on 24th.
4th, madam, 4/1/23. That too not before the nearest magistrate, but to the jurisdictional court, madam. So it is also violation of Article 22(2), madam. Not producing me before the nearest magistrate.
No, it's a case of special, I mean, NDPS.
Anyway,
That's why
madam, yes. But it seems that I was produced before the court, my lord, beyond the period of 24 hours, from 2/1/23 to 4/1. So this is my case, my lord. And arrest memo was issued, my lord, on 3rd, and in 3/1, my lord. And in their reply, my lord, written reply, page number 92, my lord. The reply of the MCB, my lord. Page number 92. Kindly come to page number 93, which has been confirmed. 93, man. The reply of the Yes. Case number 93. There are 4, my lord. 7 lines from the bottom, my lord. This is the relevant point, man. May I read? Due to huge quantity of seizure, it takes time to complete the seizure procedure. And search and seizure procedure was completed at 1800 hours on 2/1/23. Statement of Ranjit Singh was recorded on dated 2/1/23 and 3/1/23 on 2 days, my lord. He was given rest in the night of 2/1/23 and 3/1/23. Ranjit Singh was arrested at about 1750 hours. On 3/1/23, Ranjit Singh was arrested at about 1750 hours. On dated 4/1/23, Ranjit Singh was produced before Honorable Court after proper medical examination. So it has been confirmed that I was produced on 4 and arrest memo was issued on 3. While issuing arrest memo does not define arrest memo. In fact, in CRPC, arrest has not been defined. I am coming to that, my lord. My second contention, my lord, that I am in prolonged incarceration. So the charge sheet was laid, my lord, in the case. I was arrested on on 4/1/23, I was sent to judicial custody, my lord. And offense report was submitted, my lord, on 27/3/23. And charges were framed, my lord, on 10/8/23. So from charge also, my lord, it is more than 1 month,
Charge when frame 20?
10/8/23. So from date of charge also, my lord, it is 1.5 years, more than 1.5 years, my lord. So till now, 4 witnesses has been examined out of 8 listed witnesses. So only half of the witnesses are examined and half are yet to be examined. So in support of my both contention, my lord, I am relying. First one, my lord, Deepak Mahajan and another, my lord. Kindly come to page number 48, at page number 16 of the judgment, my lord. So it has, the word arrest has been defined, my lord. What is actually arrest, my lord? Lordship got it? May I read, my lord? The word arrest is derived from the French arreter, mean to stop or stay.
Oh, you're saying 48.
48, my lord. Para 48, page number 16, my lord, of the judgment. The word arrest is derived from the French arreter, meaning to stop or stay, and signifies a restraint of the person. Lexicologically, the meaning of word arrest is given in various dictionaries depending upon the circumstances in which the said expression is used. One of us, Justice Sons, my lord, S. Ratnavel Pandian, as he then was being the judge of High Court of Madras in Roshan Baby versus Joint Secretary Government of Tamil Nadu, so and so, my lord, citation, had an occasion to go into the gamut of the meaning of the word arrest with reference to the various textbooks and dictionaries. The New Encyclopedia Britannica, Halsbury Law of England, a dictionary of law by L.B. Curzon, Black's Law Dictionary, and word and phrases. On the basis of meaning given in those textbooks and lexicons, it has been held that the word arrest, when used in its ordinary and natural sense, means the apprehension or restraint or the deprivation of one's personal liberty. The question whether the person is under arrest or not depends not on the legality of the arrest, but on whether he has been deprived of his personal liberty to go wherever he pleases. When used in the legal sense in connection with criminal offense, an arrest consists in the taking into custody of another person under authority empowered by law for the purpose of holding or detaining him to answer a criminal charge or of preventing the commission of a criminal offense. The essential element to constitute an arrest in the above sense are that there must be an intent to arrest under the authority accompanied by seizure or detention of the person in the manner known to law, which is so understood by the person arrested. So it has been said that when the personal liberty is curtailed, my lord. On second, my lord, I was intercepted at Madanpur Toll Plaza. I was taken into custody. I was nowhere I was allowed to go, my lord, by the authority. So they are authorized under the law. They have taken my custody, my lord, into their hands. So from that point, within 24 hours, I should have been produced before the court, my lord, before the magistrate.
But you were shown to be arrested on 3rd only.
3rd, my lord. I am coming to that also, my lord. Next paragraph, next judgment, my lord, by the Honorable Supreme Court. Recently, it was delivered, my lord. Director of Enforcement versus Subhash Sharma, my lord. Then same issue, my lord. That come to pair number 6, my lord. Second page, my lord. This argument cannot be accepted. Admittedly, the LOC means, my lord, lookout circulation, my lord. was issued at the instance of the appellant, Director of Enforcement. By executing the LOC, the Bureau of Immigration detained the respondent at IGI Airport from 4th March 2022 on behalf of the appellant. The finding of the fact recorded in paragraph 10 is that undisputedly the physical custody of the respondent was taken over by the appellant from the Bureau of Immigration at 1100 hours on 5th March 2022. Thereafter, at 1:15 hours on 6th March 2022, an arrest memo was prepared by ED at Raipur. He was produced before the court at 3 p.m. on 6th March 2024. The perusal of the arrest order shows that the type order was kept ready. The date and time of arrest were kept blank, which appear to have been filled in by hand. Admittedly, the respondent was not produced before the nearest learned magistrate within 24 hours from 11 a.m. on 5th March 2022. Therefore, the arrest of the respondent is rendered completely illegal as a result of the violation of clause 2 of the Article 22 of the Constitution of India. Thus, the continuation of the respondent in custody without producing him before the nearest magistrate within the stipulated time of 24 hours is completely illegal, and it infringes fundamental rights under clause 2 of the Article 22 of the Constitution of India. Therefore, his arrest gets vitiated on completion of 24th hour in custody. Since there is a violation of Article 22(2) of the Constitution, even his fundamental right to liberty granted under Article 21 has been violated. Now, para number 8, my lord. So here also said that, my lord, arrest memo was issued, my lord, subsequently on 6th at 1:15 hours, my lord. But he was handed over by the airport authority on 5th at 11 hours. So Supreme Court has said that, my lord, his arrest should be from handing over the person from airport authority to the ED, my lord, on 5th, my lord. But para number 8 also says, my lord, once a court, while dealing with a bail application, finds that the fundamental right of the accused under Article 21 and 22 of the Constitution of India have been violated while arresting the accused or after arresting him, it is the duty of the court dealing with the bail application to release the accused on bail. The reason is that the arrest in such cases stand vitiated. It is the duty of the court to uphold the fundamental rights granted under Article 21, 22 of the Constitution. My lord, para number 9 says, my lord, the section 37 and 45 of the PMLA Act, my lord, the similar, my lord, twin condition has to be, my lord, satisfied. Therefore, when arrest is illegal or vitiated, bail cannot be denied on the ground of non-fulfillment of twin tests under clause 2 of the subsection 1 of section 45 of PMLA. So section 37 in indicate that also will not come. Now, my lord, next judgment, my lord, it was rendered by the Orissa High Court, my lord. Similar situation. The first line of the judgment is that, my lord, when can a person said to be under arrest? So relying upon the first judgment, which I have relied, my lord, finally come to para number 11, my lord. At page number 13 of the judgment. S.K. Hussain and others, my lord. Thus, compliance of section 57 of CRPC is in fact a compliance of the constitutional provision referred above and therefore mandatory. In other words, if the provisions are as above are found to have been violated, the same would amount to illegal detention, entitling the detainee to be set at liberty, my lord. And now can we come to para number 16, my lord. Case number 18. 16, my lord. Thus, the ratio laid down in the cases referred above is that the moment the liberty of a person is curbed or curtailed, he is said to be under arrest. My lord. So my liberty was curtailed at Madanpur Toll Plaza itself, my lord. Now kindly come to para number, my lord. 18, my lord. Page number 20, my lord. Para 18.
Para 18 from?
Page number 20, my lord. This judgment only, my
Yes,
my lord.
Yes.
Yes, my lord. Thus, imposition of restraint in the present case by physical act of apprehension of the petitioners completes the process of arrest. Therefore, mere mentioning of a different time in the memo of arrest prepared subsequently in the present case nearly 6 hours after the apprehension of the petitioners cannot have any relevance whatsoever, more so as it only serves to formalize the arrest already affected long day. So your lordship's query has been answered in this. That subsequent issuance of arrest memo does not define arrest matter. It is the actual apprehension matter when he was taken into custody. Next, my lord, para number 20, my lord. Same judgment, my lord. Para number 20, page 23, my lord. In view of
yes.
In view of what has been discussed in detail herein before, it is more than evident that learned special judge has completely misdirected himself in delving upon irrelevant consideration, ignoring thereby the seminal issue involved. Moreover, each of the grounds cited by him are found to be without any basis, as has already been discussed herein before. There are enough material on record to show that the accused person were detained in police custody for more than 24 hours. Secondly, the finding of the learned special judge that some time may have been considered for doing paperwork, etc., is nothing but granting undue leverage to the investigating officer and the staff of the court involving in the process who are guilty of committing gross illegality. It was as if the learned special judge was trying to offer explanation on behalf of the investigating forwarding officer for the apparent delay. Thirdly, the bar under section 37 of NDPS Act could not have been invoked in a case of illegal detention. Next, my lord, para 21, next page. Having held thus the question that arises in what relief the petitioner are entitled to, since the detention of the petitioner is found to be illegal, there can be no other option than to order their release forthwith. Reference may also be had in this regard to the provision under Article 21 of the Constitution of India, which grants the fundamental right to life and liberty. It is reiterated that the right to liberty is one of the most cherished objects of the Constitution of India, which overrides all other consideration and therefore cannot be taken lightly. Therefore, the petitioner had to be set at liberty. Next judgment, my lord, it was rendered by the Honorable Apex Court, my lord, in Manoj versus State of MP, my lord. Only one paragraph I am relying, my lord. Paragraph number 12, my lord. Page number 3. What happened to a person who is kept on beyond the period of 24 hours, my lord. Okay, good. I have highlighted it, my lord. If the police officer is forbidden from keeping an arrested person beyond 24 hours without order of a magistrate, what should happen to the arrested person after the said period. It is a constitutional mandate that no person shall be deprived of his personal liberty except in accordance with the procedure established in law. Close to its heels, the Constitution directs that the person arrested and detained in custody shall be produced before the nearest magistrate within 24 hours of such arrest. The only time permitted by Article 22 of the Constitution to be excluded from the said period of 24 hours is the time necessary for going from the place of arrest to the court of the magistrate. Only under two contingencies can the said direction be obviated. One is when the person arrested is an enemy alien. Second is when the arrest is under any law of preventive detention. In all other cases, the Constitution has prohibited preemptively that no person shall be detained in custody beyond the said period without the authority of a magistrate. So here, my lord, I am.
Okay, then rest are same, I think, on same.
No,
same.
my lord, rest are, my lord, regarding, my lord, prolonged incarceration, my lord. So prolonged incarceration, my lord. So firstly, my lord, that it is clear from their document itself, my lord, that I was apprehended on 2/1/2023 at Madhurpur Toll Plaza, and I was produced before the learned court, my lord, learned magistrate on 4th, my lord. So it is beyond the period of 24 hours, my lord. So regarding my lord, prolonged incarceration, my lord, I have relied some judgment, my lord. I will place only Ravi Prakash, your lordship knows.
Is here only.
Yes, my lord. So, and secondly, my lord, that one SLP was, my lord, filed before the Honorable Supreme Court. Here, there, my lord, paragraph 2, my lord, that Sharif Islam, my lord. 1 year and 6 months have been, my lord, considered as prolonged incarceration, whereas I am more than 2 years in this case, my lord. Secondly, my lord, some bail applications of our High Court, my lord, I have preferred. Sorry, I have relied, my lord. Only one I will read, my lord. Bail application number 2475, my lord. That is Harish Mia versus State of Assam, my lord. So relying upon this Ravi Prakash, my lord, this judgment was rendered by the coordinate bench, my lord. Paragraph number 13, my lord. Paragraph 13, my lord. Though this case involves commercial quantity of methamphetamine weighing so and so, and charge has been framed against the present petitioner under section 22C of the NDPS Act 1985, and apparently it appears that the embargo of section 37 of NDPS Act is applicable in the instant case. However, the petitioner has been detained behind the bar since last 746 days, and the charge was also framed against him on 28/1/22, 1 year, 7 months, and 2 days ago. However, not a single prosecution witness has been examined yet. The delay in trial is not due to the fault of the petitioner, as he is already in custody. The petitioner has a right to get speedy trial under Article 21 of the Constitution of India. Now, paragraph number 18, my lord. In the instant case, at page number 10, my lord. In the instant case, the petitioner has been behind the bar since last 746 days, and even after framing of charge under section 22C of the NDPS Act against him, 1 year, 7 months, and 2 days has elapsed, and the prosecution side is yet to examine any witness, and there is unlikely that the trial would culminate immediately. Under such circumstances, and in view of discussion made herein above, this court is of the considered opinion that the present petitioner has been languishing behind the bar since 2 years, 16 days, and the prosecution is yet to examine any witness. His prolonged incarceration under the fact and circumstances of the case overrides the embargo of section 37 of NDPS Act, and he is entitled to get bail under such circumstances. So 2 years, 16 days, my lord, it has been considered as prolonged incarceration. So similar to my case. So in that aspect also, I am entitled for bail, my lord. So in the interim bail was granted, my lord, I have voluntarily appeared, my lord. So I am with good intention to face the trial, my lord. I will face the trial, my lord. And apart from that, my lord, constitutional obligations has been not been followed by the respondent, my lord. This is my humble submission.
But my learned is argued on two counts. One that Article 22 and prorogation. With regard to first, let's see. I'm grateful to my learned friend that he has pointed out. Let's see, may come to page 93 of my objection. Last 7 lines. I again want to place before a let's see. Page 93, last 8 lines. My learned friend read out 6 lines. I want to add 2 more lines. Yes, I am reading the entire paragraph 4 now. That the contention made by the accused petitioner in paragraph 5, 6, 7, 8, 9, and 10. The answering deponent said that a truck was intercepted at Madhupur Toll Plaza in presence of 2 independent witnesses. At the time of interception, Sri Ranjit Singh confessed that there are 220 packets country feet loaded in the truck, and there are about 6,000 bottles of cough syrup containing specially made cavity under the surface of loading area of the truck, and over which lot of poultry feeds bags were loaded to conceal the packets of cough syrup. He also confessed that he has no any document of loaded cough syrup due to late night, no labor found at the spot, and there was no mechanic found to open the cavity due to the safety and security of the vehicle, as well as the intersected suspected persons and items loaded in the truck. Ranjit Singh and both the independent persons were requested to come to NCB office for further search of the truck, and they willing to come to NCB office for further search. They reached the office of the NCB at about 5 hours on 2/1/2023. After reaching at NCB office, Ranjit Singh and both independent witnesses were given rest. Then search was again at about 10 hours on 2/1/23. Due to huge quantity of seeds, it takes time to complete the seizure procedure, and search and procedure was completed at around 18 hours on 2/1/2023. The statement of Ranjit Singh was recorded on 2/1/2023, and 3/1/23 was given the rest in the night on 2/1/23. On 3/1/23, Ranjit Singh was arrested at about 17:50 hours. On 4/1/23, Ranjit Singh was produced before the Honorable Court after proper medical examination. So he was arrested on 3/1/23 at 17:50 hours. And within 24 hours, he was produced before the London Trial Court. Lordship, here, the arrest was made on 4/3/1/23, and the bail application has been filed on on 31st July 2024. In the meantime, final complaint was filed. Out of 8 witnesses, 4 has been already been examined. Not 4. No, till date 4 has been examined, but till the filing of the complaint, probably 3 witnesses were examined. Final complaint was filed on 1/7/23. And Lordship,
how many witnesses is it?
Out of 8, 4 has been examined till date. And next date is fixed on 24th of April. And Lordship, Kapil Vadan, Lordship, today I have not brought the judgment and supply to your Lordship. That was with respect to 67, and the right was accrued to the accused when he has not availed his right, subsequently he cannot take this right for violation of 167. And an argument was made in that case also regarding violation of his fundamental right. I'll produce that judgment. And here, Lordship, there is no any violation is made by the authority because the arrest memo was supplied to him on 3/1. Probably that is not in the next with the bail application. But it is admitted fact that he was arrested on 3/1 and produced on 4/1. This is admitted fact. So there is no violation of any fundamental right. If it is any, Lordship, he has waived his right by not coming to this honorable court at the relevant time. And this is a bail application, not any causing application. And Kapil Vardhan is very clear, Lordship, today I have not brought, but in one of coordinate the judgment has been made, reference has been made in the Jitul Ali's case. Then Lordship, another ground has been taken, many judgment has been placed, but none of the facts of this case are between with the case of this case. So all these judgments, Lordship, not relevant, cannot be relied on these facts of circumstances of this case. Now, Lordship, coming to the second question, long incarnation. Lordship has seen the final complaint. He was arrested on 4/1/23. About 2 years has been completed by now. Lordship, in the meantime, the final complaint was filed on 1/7/2023. Charge was framed on 10/8/2023. And till date, Lordship, out of 8, 4 witnesses were examined. And the
charge frame on?
Charge frame on 10/8/2023. And Lordship, the PW4 was started. His chief was completed on 4/3. Thereafter, on 29/3/2025, his course was completed. And next date is fixed on 24/2025. My learned friend has relied on many judgments, long incarnation, but none of the judgment, Lordship, that long incarnation is defined. Yes, in Ravi Prakash, he was granted bail, but here in this case, Lordship, I want to place the relevant paragraph of bail application. Lordship, page 60, the bail application. He from his subject position. It is admitted to it. And in the Ravi Prakash, Lordship, to see in these 3 occupants were arrested from the truck, and he was the occupant of the truck only. Yeah. Yes, paragraph 63, role of accused Ranjit Singh. Paragraph 1, arrested accused Ranjit Singh was driver of the seized truck bearing registration number so and contraband, that is 6483 bottles of potable Vincidals cup syrup was seized from conscious position of the Ranjit Singh. And during the stop interrogation, Ranjit Singh admitted that he was well aware of the fact that he was carrying all these seized bottles and codeine-based cup syrup with brand name Vincidal with concealed in the truck bearing number so and so. Ranjit Singh admitted in his voluntary statement that he would have to be paid rupees 25,000 by Mithun Ghosh after reaching at Agartala with the contraband. That means he was carrying, with his full knowledge, he was carrying this contraband for the consideration of money. And he admitted that he don't have any document to justify his carrying goods. Accused Ranjit Singh is the main accomplice of supplier Rakesh Kumar and received Mithun Ghosh vehicle provided Pramod Kumar Yadav des Tinku. Accused Ranjit Singh has disclosed in his voluntary statement recorded under section 67C of NDPS Act that he was consciously involved in trafficking the codeine-based Vincidal cup syrup for money. And beside this, Lordship, he is a habitual offender. In my objection, Lordship, in last paragraph we have mentioned in page 94, Lordship. paragraph 6, third paragraph. Page 94.
Paragraph 6.
And there are 6 last 3 paragraphs. During investigation, it came to that the accused Ranjit Singh is the main accomplice of supplier Rakesh Kumar and receiver Mithun Ghosh. Vehicle provided so and so. That number of mobile communications has also proved the involvement of Ranjit Singh with other suspected accused of the case. That Ranjit Singh is habitual offender and was arrested in NDPS case in connection with Teliamura PS case number so and so on 23/1/2022 and released on therefore was released on bail. With the habitual offender of carrying out this contraband goods. And Lordship, another submission. Earlier, Lordship, before Satyendra Prasad until Section 436 capital was not applicable. From that judgment, Honorable Supreme Court says that in case of NDPS also, the Section 436 will be applicable. I want to place 436 also. Maximum period for which an under trial prison can be detained. So maximum period should be calculated. In case of NDPS, maximum period is 20 years. We calculate by that it comes to 10 years. Here he was in jail for about more than two years, 2 months and more. So we cannot say that it is a long incarceration. And in Ravi Prakash Sale in Muslim, Muhammad Muslim, nothing was recovered from both the accused. In Muhammad Muslim, he was in jail for more than 7.5 years. In case of Ravi Prakash, he was about 3 years he was in jail. But nothing was recovered from them. All were accomplices of they were occupant of the truck from the seized truck or any vehicle. And in one judgment, Lordship, Honorable Supreme Court says that in Pallavi Ahmed Rimutta, here Lordship, Karnataka High Court granted bail to 3 accused. Then the NCT approached Honorable Supreme Court in paragraph 11. Paragraph 11, last 5 lines first. We are of the firm view that accused A2 cannot seek parity with the aforesaid co-accused, and as such, benefit could not have been extended to him in view of Section 37 of the Act, when he was found to be in conscious possession of commercial quantity of psychotropic substance as contemplated under NDPS Act. This being the position, the petition of the NCB succeeded in SFB so and so. So when any contraband has been recovered from conscious possession of a person, Supreme Court says he is not entitled to pay. Now, Lordship, I want to place one judgment, recent judgment, where Lordship, what happened? There was non-compliance of Section 52A. While passing the judgment, Supreme Court says that in paragraph 39, 1 and 2. In supplying copy, I am just reading for my benefit also. The upshot of the above discussion may summarize as under. The provision of NDPS Act are required to be interpreted keeping in mind the scheme, object and purpose of the Act, and also the impact on the society as a whole. It is to be interpreted literally, not liberally, which may ultimately frustrate the object, purpose, and preamble of the Act. 2. While considering the application for bail, the court must bear in mind the provision of Section 37 of NDPS Act, which are mandatory in nature. Recording of finding as mandated in Section 37 is sine qua non, is known for granting bail to the accused involved in the offence under NDPS Act. Paragraph 39, clause 1 and 2. Here, main argument of the petitioner is that there is a violation of Article 22 because he was not produced in the court, but it is not correct. The court says that he was arrested on 3 and produced on 4. We stated in our affidavit also. And regarding, and Lordship, that was done in 2023. Now we are in 25. In the meantime, the final complaint is, if there is any violation, probably that benefit not, he cannot entitle the benefit of that at this stage in view of the escape advance case. I placed the judgment today, I have not brought, but it is referred in one of the judgment I placed before you. Second log incarnation, Lordship, in none of the judgment of Honorable Supreme Court, which whether 1 year, 2 year, or 3 year, or 5 year will be a long incarnation. But in case of Santiago until when Supreme Court says that 436A, then we have to calculate, then it comes to 10 years. If the 10 years is reached, then we can say that is a long increment. Here also regularly witnesses are coming and they are being examined. In view of the same lordship, I think this is fair to make out any case for granting bail. Lordship may direct the trial court to complete the trial within very shortest period. And witnesses are regularly coming, lordship. Lordship, I am giving the dates. The first witness was examined on 5/9/23. Then second was 17/1/24. Then 4/3/24. Another witness was examined. P number 4 was chief was completed on 4/3/25. Then again on 29/3/25, his cross was completed. Now next date is fixed on 24th of May 2024. 24th of April 25. And lordship record is before your lordship. There is a record whether we are correct or not. But it is admitted that he was arrested on 3 and he was produced on 4. And lordship Bhagwan case I'll place before your lordship. Tomorrow I'll place that judgment. That is specifically stated that if any right has been accrued to the accused person, he has to avail immediately. If he has not, then he is not entitled to the benefit. But in this case, lordship, in my humble submission, there is no violation of any fundamental right of the petitioner. And in case of NDPS, lordship, and we have explained how things were moved, and that is been placed before lordship by filing affidavit in the position.
One reply, my lord. Regarding the violation of Article 22, my lord, my learned senior has said that I cannot claim now, my lord. But in Pravir Purkasta case, my lord, it has been held that, my lord, once it is illegal, it will carry forward till the end. My lord, one relevant point, paragraph, only one judgment I have, one copy I have, my lord. I am married, my lord. The right to life and liberty is the most sacrosanct fundamental right granted under Article 20, 21, 22 of the Constitution of India. Any attempt to encroach upon this fundamental right has been frowned upon by this court in a catena of decisions. In this regard, we may refer to the following observation made by this court in the case of Roy VD versus State of Kerala. What it has said, my lord, the life and liberty of an individual is so sacrosanct that it cannot be allowed to be interfered with except under the authority of law. It is the principle which has been recognized and applied in all civilized countries. In our constitution, Article 21 grants protection of life and personal liberty, not only to citizens of India, but also to aliens, my lord. Thus, any attempt to violate such fundamental right granted under Article 20, 21, and 22 of the Constitution of India would have to be dealt strictly, my lord. Next, paragraph number 30 says, my lord, hence, we have no hesitation in reiterating that the requirement to communicate the ground of arrest of the ground of detention in writing to a person arrested in connection with an offense or a person placed under preventive detention as provided under Article 22(1) and 22(5) of the Constitution of India is sacrosanct and cannot be breached under any situation. So same, it is regarding ground of arrest. And I am onto the, my lord, producing before the magistrate within 24 hours, my lord. So non-compliance of this fundamental constitutional requirement and statutory mandate would lead to the custody of the detention being rendered illegal as the case may be, my lord. So it is very clear, my lord. Once constitutional right has been violated, my lord, it will carry forward. So I can claim.
Please by me, showing that paragraph 17 was. With regard to fundamental, this is by three judge bench. It is better that a personal liberty cannot be taken away except in accordance with
Yes, I have this one. You have already.
Yes. And if I place that advance judgment tomorrow.
Also it does.
It is very clear.
Now, see, Mr. Ali, the question is that there's some petitions are being filed before us, taking the ground of arrest was not intimated or mentioned. So on that regard, these two judgments are there, Mr. Pavipur.
Yes, I have just given.
But one's case was there. Most probably it was passed in 167 in connection.
167.
In connection with 167 too. Therein it is held that this on that ground, I mean what Mr. Kyle is saying, that was the observation, I think, but it is not before us now. I have sent to say. So you are taking this sole ground that 22-1 violation. Sorry, 22-2.
And in prolonged incarceration.
And prolonged.
Much of. I'll take 30 and place this.
All right.
Yes. I'm feeling well also. I don't know why. I'm going to double into more battery and balance, and I didn't take it. Saturday, I took that medicine. I get a check. I say, how open supplemental electrolyte 41.
41.
One I is there.
Yes. This IA has been filed, Lordship. In this case, charge sheet has been filed. The petitioner is appearing before the learned court below on trial. While granting bail, Your Lordship, by this honorable court, two conditions were imposed and which are causing some hardship to the petitioner. He is a practicing advocate of Your Lordship. Now, on this ground, we have approached this honorable seeking some modification of these two bail conditions. To think that the bail was granted way back on 11/10/2018 by this honorable court, annexed to page 11. There were two bail conditions. Some bail conditions were there, which are at page number 25. Now the case is in the evidence stage. The case is continuing. It is a PSC case, Lordship. APSC case, this APSC.
Oh, APSC.
Charge sheeted case, yes, sir. The petitioner was in the HCS category. He was suspended and terminated. Now he is facing the trial along with all other accused persons.
So bail conditions are at page
25.
You are on basically condition number
B, Your Lordship.
B.
And E.
B and E.
That on every date he has to remain present, Your Lordship. This is one of the condition. And E says that if he wants to leave the territorial limit of the court, he will have to take prior permission, Your Lordship. Now he is appearing, Your Lordship, that on certain days, if he cannot go due to some personal inconveniences, and engaged advocate will represent him, because they are doing like this. And point E, Your Lordship, sometimes he has to go to some other courts also, Your Lordship.
For these reasons, he could not go out or he is already on bail, I think.
He's on bail.
Acha.
So these twin conditions are causing hardship on two grounds. At number one, he's an advocate, your lordship, by profession. He's also practicing nowadays. Now, sometimes he has to go to some other courts also. So,
And otherwise, he is not on a SS officer. He was not the SS officer. No, he did the APSS scheme matter.
Yes, yes, yes.
So how the advocate is entangled with this one?
He was an
he cleared. He cleared the SSA.
Cleared the
Yes,
acha.
yes, yes. But subsequently, he also worked for about 2 years as a circle officer. But unfortunately, things unfolded, and now, your lordship. So one is that he is an advocate. Sometimes he has to go outside on many occasions. Every time he has to file an application. One problem is there, and secondly, your lordship, his wife is also doing a business in cloth store, and they have a minor child. Sometimes he has to go outside for giving orders for clothes in Bombay or Calcutta, your lordship. And so the wife cannot go alone with the minor child. He has to accompany him. So these things, otherwise he's facing the trial and lordship. In this round, your lordship, I'd like to refer to judgments of this court, your lordship. Some other persons have approved this honorable court seeking similar request, page number 30. And
Page
this
number?
30. And this honorable court has been pleased to relax both the conditions. Page 30 is one order and page 32 is another order, your lordship. Other two co-accused, your lordship, who are also granted bail by you of the same bail order. Page 30, lordship court. Page 3. So in this, there was a prayer for relaxing the condition number E. And the honorable court at page 31, your lordship, was pleased. Otherwise, also they are not going to prejudice. It is not that I will escape from the trial. I am facing the trial. I'll continue. Only these two conditions are causing some hardship to your lordship. And page 32 is another order passed by coordinate bench of this honorable court. And following the earlier order and also on the ground of parity, in subsequent case, in this case also the honorable court was pleased at page 34. After considering the submissions at the bar, I deemed fit to modify the order. Accordingly, the order date so and so, passed in so and so is hereby modified to the extent that the conditions B and E shall stand cancelled.
Basically, he is on two conditions.
Yes, lordship. I have gone through the first order, lordship, at page 30. Basically, these conditions were relaxed on the ground that the petitioner therein, his wife was suffering from serious ailment. And yes, lordship. They were required to surrender their passport also.
Yes, they have surrendered.
They have surrendered. So, lordship, the question of running away may not arise, lordship. And this being an old matter, lordship. And
Okay. Submission. Please study and report us. The same, more or less same order. The condition he submitted, Mr. Sunil submitted. And the learned counsel for the petitioner submitted that the present petitioner is was granted with bail by the order dated 11 Jan 2018. And at present he is regularly appeared and facing the trial. But due to bail conditions, namely conditions put on para number B and E, created some problem for the present petitioner. Being the advocate, he has to go outside the jurisdiction of this court, the jurisdiction of the trial court, to conduct some cases and at the same time, his wife has some business of clothes, and for that purpose, sometimes he has to accompany his wife to other states, as his wife cannot go alone due to wife alone, as they have also a minor child. However, the petitioner is appearing before the learned trial court below and facing the trial, and accordingly paid for switch. Taking the okay, your conditions will be relaxed. Page number 30 or 30. Condition B, condition number B and E has to be relaxed.